Hi guys, it's Kathy. I hope you're doing well. Okay, we made it to 2023, January. Nope, July. So we're going to get to 2024 today. 2023 is just an hour and a 7 minute, and then we go right into 2024. So, and that'll be the normal same judge. It won't be bouncing all around to different judges. Just so you know, she makes it today. And she brought a prop. She makes it with a prop. I love props. I love when they bring props. When when I was doing the Kelly trials, it was getting kind of boring. And then the defense attorney brought in a skeleton. Yes, she did. Yep. And she made people stick sticks in it and things like that, and it was really boring. But there was a skeleton. I love props. So let's get to it. Let's get to it. Let's get to it. And today he has Groot and a bunny, and I just don't know what that is. I just can't figure it out. I am Groot. All right, here we go.
The
Look,
we have,
there's her prop.
we have
She brought in a big picture of her adorable daughter. Adorable.
Ms. Hurd. Who else do we have here?
Your Honor, this is Matt Friedman. I believe my client's also present via Blue Jeans. I was having some connectivity issues. Associate of mine, Cameron Brown, was on, but Cameron, you can go ahead and log off. I've got this.
Okay.
Okay, sounds good.
Okay.
I missed it. Who's that? Who was that guy? Was he for not her lawyer? It definitely wasn't her lawyer, right? We'll find out again.
No, everyone's received the report, correct? From
No.
Oh, you didn't?
No.
Oh, okay. We need to make a copy of the report and provide it to this young lady. And Mr. Friedman, do you and your client have it?
We need a copy too, Judge.
So, Your Honor,
please.
when we got the email from, I believe it was Your Honor's law clerk, it was a request of Donna's house for the report. I don't recall that we ever, and we noted, hey, this, there's nothing attached, and then I reread the email and I told my
Okay,
staff
so
that
we
it was
can
just a
send
request.
them the copy as well.
I don't anticipate there's much that I need to see in there, Your Honor, but I do appreciate you giving the copy.
Okay.
Don't say hi to him.
So
Don't say hi to him. No.
we'll have
No.
the report in a minute, and we'll go from there.
We shun him today. We shun Fozzie.
I know
Shame.
in the past
Shame.
we had discussed about families first instead of Donna's house, but this referral was to Donna's house facility. And it involved
Your
12
Honor,
visits.
if you'll recall, the opposing party was objecting to Families First and alleging they
Right.
were, I guess, conspiring to.
We're having it copied now, but the court had read the report and it indicated, my notes indicate visits began on April 13th. There were 12 recorded supervised visits since the orientation of April 6th. Each visit, the parties were on time. Child, as Ashlyn greeted with hugs and kisses. Interactions were appropriate with toys, books, potty training, car seat, etc. I don't know why they mentioned potty train. We're dealing with a
Because she's
7-year-old.
7 years old
Dealing with a
and she was
7-year-old.
potty trained already, and she's regressed.
She's
in
7.
nose care.
She's 7, right?
Yep. She's
Yeah,
regressed
okay,
significantly
so
in
that,
nose
I
care.
guess, explains it, okay. And that mom helped with the toileting and helped with the pull-ups. And they said only on June 15th was mom advised against an inappropriate skirt. I'm not sure what that was about, but mom accepted the redirection. And it said all visits were safe, appropriate, happy, and without incident. So, starting with Mr. Friedman, now that you have
Go Eagles.
the
Woo.
report, any
I'm sending
commentary?
it over right
Oh, he's sending it to you now. So let's
I-
everyone take a
I'll wait.
moment. I'll let everyone take a moment and read it, and then they can react. I already read it and told you what the highlights I thought.
Your
were
Honor,
important.
I know you'll send it. I would just say, I trust Your Honor's summary.
Yeah, but
um,
we can, if it's arriving, you can take a moment. It's only a page and
Well,
a half, so you can take a
I
moment.
would
You
just
guys
see,
can
Judge,
take a moment. Did you receive it yet?
I can check right now.
Oh.
Judge. I was just saying, I'm not real sure. I know Your Honor set this just to make sure it was going forward, and I appreciate it, but I'm not real sure, given that this appeal is still pending, what exactly we can do beyond, I think that the courtesy that you did, Ms. Hurd, previously by
Oh.
changing the location.
No. Eagles fans aren't terrible. They're the worst. They're the worst in the NFL. They're the ones that have an actual court with a judge down in the stadium for people who misbehave. Oh, they're so bad.
Yeah, but you know, there are exceptions if we deal with critical constitutional or public policy matters such as access to children or definitely flowing of child support. Appeals don't necessarily stop that. It stops a court from dramatically altering a support or a visitation.
The first time I went to an Eagles game, as I was walking into the stadium, two guards each had a guy by, one guard had one of his arms, the other guard had the other arms. He was dragging him backwards out of the stadium. And that was my first taste of the Eagles stadium. It was amazing. It was epic.
Or custodial schedule, but doesn't necessarily free some incremental steps. But we'll let me see what there's no report on the status of this appeal, is there?
No, it's just.
Briefing's concluded, Your Honor.
Okay.
Yeah, briefing's concluded. We're just waiting a decision. I don't anticipate that the court will set oral argument, but I suppose they could, or they'll likely, I would anticipate, just decide it on the paper.
There was appeal to Supreme Court, then it went to Court of Appeals. These things could take forever. Who appealed it?
I feel.
Well, if
Ms.
you
Hurd.
appealed it, that's why taking actions without getting legal advice is incredibly difficult and costly because you 99% remove the court's ability to do anything. You may wind up with an appellate decision that's different from the courts, but in the meantime, there's not much the court can do. But that being said, with that understood, one second. With that understood, Mr. Friedman raised an issue: what ability does the court have? If everyone post-appeal brought into a concept that we needed to tread lightly, and that if we got a report that mom's visitations were proceeding adequately, that we could proceed to unsupervised, I don't think that would do violence to the appeal. But has everyone read the report?
I briefly skimmed through it.
I'm sorry?
I've skimmed.
Okay, Mom has. Mr. Friedman, did you receive it yet?
I did, Judge. I just glanced through it.
I just
Okay, it's short enough that you guys can actually read it. It's a page. And
I
if you guys actually want a
read
few
the
minutes to
report.
actually read and absorb it and take notes, that's fine.
I
Or if
didn't
you
think
feel
there was a whole lot there.
comfortable You can. Mr. Friedman, go ahead. Then we'll hear from Mom.
As I said, Judge, in going through it, Your Honor, made a summation of what was contained therein. I don't see anything that deviates from that. It appears to be there's 12 visits. It discusses, the various interactions between Mom and Aslan. I think you've landed that plane successfully. I guess my question, Judge, is I don't know, and Your Honor, and I know that you have a tremendous caseload, and so I know each individual case and the details of it, especially on a status check hearing. But when we were before Your Honor last time, you made very much the same statements to Ms. Hurd about the propriety of her appeal, and what might make some more sense in terms of and at the time I said, look, Ms. Hurd, if she was
I
desirous of
remember
dismissing the
people who
appeal,
are unrepresented and don't like orders, instead of a quick fix, which often just coming to a new hearing can change things dramatically. People often take the ill-advised action of jamming us all up for years, and in a lot of cases, the only person who suffers is the one who did the appeal, and no one bothers advising them that here's the paperwork for an appeal, and they charge people money, but no one's advising them. Do you realize that what can happen here? These appeals are for unique situations, like if a judge really is erroneous on some complex financial issue. But 99.9% of the time, if it deals with access of children issues, people are far better served rather than waiting 3 years to see if some higher court tells the court they were wrong. It makes sense just to move the case forward, to correct what needs to be corrected, persuade the judge that they need to take a different tact. It's just much more effective. But, and I reviewed that last time.
Louise, thank you so much. Thank you, thank you, thank you. That's awesome. Make it green. Um, I just posted in Discord. Bren sent me the greatest little summary of what has gone on up to date to here. So it's in Discord. The link is in Discord. It's pretty good. I know. Anthony, make sure you have your gifting turned on so that you can get a membership if someone gifts them out.
If she's convinced, and I told her, don't take my word for it, please don't. Please get free legal advice. Go to the Ask a Lawyer. If someone thought, if there's some skilled lawyer who thought, yeah, your rights are better served by waiting years to see what some of the court may think of it, I can't really comment on that. I think that she can and should, and if you haven't, I'm going to reiterate, and she can go to the Ask a Lawyer at the Self-Help Center for free on Thursdays, 2 to 5, and you have, if someone told her that this is a brilliant idea, and that without pointing out the freezing effect, and it's very frustrating to the court, because sometimes, because I don't really, I'm not concerned about eventual results of an appeal. That's what these people are up there. They're up, these wise people, 3 on 1.7 or the other. That's why they're there to tell me when I'm wrong and need to do something differently. So that's the system, and that's what it is. That's not what concerns me. It concerns me that people come to court and say, I want you to do something affirmatively for me because I deserve that now, my child deserves it. And I said, you just took away my authority and ability to do so to a large extent. And it's an incredible source of frustration. Now, that said, I believe that if the parties post-appeal agreed to proceeding with a supervised visitation schedule, which is a temporary artificial way of parenting, which the court frowns on and generally wants to lift as soon as possible, that if the referral to the supervised visitation was not something highly erroneous that did violence to the appeal, that proceeding forward with normalizing visitation would not do violence to the appeal as well. And when people do push these things forward and they say, I want this, I want that, then I say, I don't want to ever pressure someone to say, you need to dismiss an appeal if they or their attorneys believe they have valid reasons. There's many cases I'm curious to see how the appellate courts think of a point a lawyer ruled on, whether they agree or not. But I do tend to get frustrated when someone says, do this, do this, do that, and I said, yeah, that's really interesting. You just spent a lot of time and effort to create a system where I can't do this, this, and that. And that's what I want Mom to understand, that even if she's right, and even if the court should proceed with doing A, B, and C today, if someone, largely because they did not have legal advice, deprived someone of doing A, B, and C, and that's why appeals on timeshares or custodial situations should be the last resorts of last resorts. Appeals should be, someone ripped me off for 200 grand equity in a home, or this business was divided in a way where someone got 300 grand more than the other. But appealing these fluid type things that change month to month is a concern. But all I can reiterate to Mom is to continue to seek additional legal advice, because you're quite correct. I'm really limited as to what I can do because of the box we're painted into.
But I did not buy eggs to prepare for the snowstorm. I did not buy eggs. First off, because even if there's a snowstorm, I can still get to the store easily. Because I can do that. Second off, they're freaking expensive. Third, I don't think I want an egg tomorrow. I'm going to go with, for $6, yeah, I got beer. I got lots of beer. I got lots of beer and I got Fritos. So what else do we need? I'm good. I hope everybody has beer and Fritos.
Now, with that said, did you have any commentary on the content of the report itself, which seems to be generally positive? So there's a couple bumps in the road, but nothing serious. Do you have any commentary on that, Mr.
I need
Friedman?
chickens.
Judge, as I said, as I indicated before, I don't with respect to the report. And, everything Your Honor said is what, the conversations I had with Ms. Hurd before, the majority of her filings. At this point, the only real shame of it is that it's continuing to cost my client a tremendous amount of money with the serial filings before this court and in the Supreme Court, and there have been a litany. And again, Ms. Hurd, while her support obligations, and we addressed this last time we were here, she's not done anything to provide any support. And I understood Your Honor's position last time. What you weren't going to touch that. I think I really, again, Judge, I don't believe this court, absent Ms. Hurd's desire to seek a dismissal of that appeal, and she can contact my office to discuss that. Our hands are tied too. There's certainly aspects of this case we'd want to bring on. I don't think it rises to the level of a McManley request for, let's say, enforcing child support. Or modifying it because we think mom's working now and still not providing support. And so my hands are tied. We didn't bring this appeal, right? My client didn't take it. We tried to caution against it. And he's just continuing to fork over a tremendous amount of money simply to keep, on par with what Ms. Hurd's doing. So,
And
I agree with Your Honor.
is this appeal I have to refresh this, it was mainly about whatever timeshare or custodial situation was imposed, or are there some additional financial issues that were
There's additional financial.
embraced, or was it mainly the timeshare?
No, it's all of it.
What was it?
Amounts that.
Because if it was
well,
just financial or property issues, then the court could properly proceed with modifying a custodial situation. But if it's also included the custodial situation, which I believe it did, therein lies the problem. So, Mr. Friedman, what else do you want to mention? Then we'll hear from Mom. Mr. Friedman, did you have any other commentary on the report?
The report, Judge, no, I
Okay.
don't. I believe you're accurate in stating that, first of all, the property and financial issues are non-existent. There was a custody, primarily, these issues, I suppose, on some of the financials with respect to, child support or something. But, that's what this case, that's Ms. Hurd's just appealed to everything that Your Honor did from the fact that, she failed to appear at her trial and believes it was an error for you to enter an order despite her failing to appear, and filing a motion to continue, I think some, 2 minutes or so before the trial was set to begin, down through everything else that happened thereafter. The supervised visits are occurring. There's been some communication issues. Ms. Hurd continues to pepper my office with correspondence and make demands, but largely we've been able to work through Donna's house, and the one time my client needed a reschedule, he did. Ms. Hurd rescheduled one time, but other than that, I think Your Honors gives a fair reading to the report. I don't know what else there is to talk about. I think you've given Ms. Hurd a lot of, as much, I don't want to say advice, as much guidance from the bench as you can as to what makes sense. And it's unfortunate, again,
Has
because
she
my
called
client's
you
so long
since
to
this
drive.
supervised visitation report was issued, or this 12 visits occurred?
She said,
With a
we've
visitation,
exchanged,
with a visitation proposal?
no, we've exchanged written correspondence, but most of it has been her making demands, for example, demanding that the child be able to travel out of state with her for an extended period of time, demands that members of her family could take the child out of state.
And now that we have the report, which seems to be a positive one, is there any possibility these two could effectively mediate anything? Would a
I don't know,
mediation
Your Honor.
referral be a bad idea? As you said,
That's not been my-
there's a lot of time and expense being eaten up with this process with the appeal. But
I can
whatever.
tell you, I always advise my clients to keep their minds open
Okay.
and be willing to consider. So I never say never. Obviously, Judge, there's a lot of acrimony. Certainly, what I received from Ms. Hurd, I believe what the court and your staff received from Ms. Hurd. So, I would be dubious of of likelihood of success, but I would certainly encourage my client to attempt if that's your orders. I would just, again, as I did last time, just make a strong suggestion that we do have some jurisdictional issues under Honeycutt.
My son just went to Texas recently. Remember when he was in Texas? It was like, was it a week ago? He comes home and he's like, Mom, I had to keep the faucets running the whole time because they were scared their pipes were going to freeze. He said, when I left the faucets running. They were dripping. I wasn't allowed to turn them off because they thought their pipes were going to freeze. We don't do that. Our pipes are nice and good.
And given that I briefed the appeal and I know what Ms. Hurd has placed on appeal, I do think she has largely, if not completely, other than an emergency situation under McManley, deprived this court of much of its jurisdiction without petitioning the court for a remand or dismissal.
Okay.
I think that's where we are.
Before we ask you, Mom, to comment on the report, since the last hearing, since I've been strongly urging this, have you spoken to any attorneys?
Have I?
Yeah.
Yes, I've seeked counsel and I've seeked.
Are you interested in retaining anyone?
I don't have the financial means
Okay.
to retain anyone.
What would you like to tell us relative to the report in the Donna's house situation?
As been said before, it's mostly positive. That's only reason why we're here today. We're not here to go into anything else. Like you stated, you don't have the jurisdiction of rehashing of everything we did last hearing. I do want to mention that there were 2 cancels not made by me. They were made by Mr. Perry. One was a no-call, no-show.
Okay.
And the other one was 2 days before. And I'm not allowed makeup visitations per Donna's house. So I dismissed 2 visits because of Mr. Perry. When she did this last time, the Families First failed to put that in
What do
the
you days
report,
off
too.
work each week?
I work,
Okay.
I have a flexible schedule, so
Now,
the best days are weekends.
Now,
for
with
me.
the understanding, I'm not in the mood this morning for an absurd answer to a question, because with all the hearings I've been through this morning, they've been tense. So when I ask you what kind of contact you're looking for at this point,
At this
it
point,
doesn't make sense for you to say, give me custody or half
Right.
custody, because as
I'm
you
not.
well know, that's
just
all
asking
on,
for
that
the
whole thing's on
supervision.
appeal. So what type of normalized
I'm just
visitation?
asking for the supervised visitations to be lifted.
Okay, and what schedule are you looking for?
I would ask for weekends, because weekends are the
Okay,
best.
that's when you're off.
Yes,
Okay.
and that's all. I
Okay,
understand
Mr.
that
Friedman,
done.
I asked her to answer the question in a way which made sense, and she did. She didn't say, give me custody or half custody, just lift supervision and focus the visitation on my days off work. Now, I don't know to what extent he's off work and
He's off
off
on
on weekends. Now, this situation, the court's gonna make the findings that it does believe that since the party stipulated to proceed with this process, or at least no one objected or ran a writ on this Donna's House process, that common sense wise, legal wise, and procedure wise, the court
I am Groot.
everyone was on notice that if we had a sufficient report that we would proceed from the very artificial, restrictive type of parenting of a supervised situation, which the court seeks to lift as soon as reasonably proper. So some sort of visitation is appropriate. I'm not gonna do any violence to any financial issues. Or if the custodial designation of any sort was on appeal, obviously Mom knows that until such appeal is resolved and I get a remand, giving me what my instructions
Honor,
are,
respectfully,
she
this
cannot
was
be
this was-
awarded primary custody or joint physical custody. But I do believe under these circumstances, the court can normalize Mom's visitation. And if someone runs a writ on that and says, no, that's wrong, then so be it. But for now, that's what the court believes, because I believe a court of review would say, well, everyone's on notice when there's a supervised visitation, that's just a temporary remedy, and we're gonna pull the Band-Aid off of that and start getting to some substantive basic constitutional rights of parenting after that. So someone knew that logically, legally, and procedurally, an adequate supervised visitation report leads to unsupervised visitation. So if someone believed the court didn't have the jurisdiction to lift the supervision, there should have been a writ run on the very issue of the referral to the agency. So with that said,
Your Honor,
and if there is
respectfully, and I was-
one, and if there is
You're
one
not gonna let me-
subsequently, court of course will immediately comply with whatever the result.
Has anybody seen Raven lately? Raven, not Raven. We see Raven. Right in OJ. Has anybody seen Raven? Anthony, you should meet Raven.
But at this point, the court's gonna attempt to normalize the contact, so she's off weekends.
Your Honor, may I make a record respectfully? I understand you've had a long morning. but
I
think it's
kind of
important.
made it, I kind of made it for you in the
No, you
sense
made-
that
you made-
if the
Your Honor,
court's,
respectfully,
if the
you made
court's
your record. You did not allow me to
observation
make my
is,
record.
or if the court's observation is erroneous and that it does go beyond, but whatever, okay.
Just briefly, Judge, when we were here last time, the argument that Your Honor, or the analysis you're engaging in is by consent.
Pardon?
It's actually what essentially you're saying is that because my client was amenable to changing from Families First to Donna's House, that he therefore litigated by consent the jurisdictional
No,
issue,
that's
which
not-
I don't
that's-
believe
what
Honeycutt
I'm
would allow him
saying,
to
and
do.
I'll stick with it. If it's wrong, it's wrong. It's not gonna do us any good to argue now. I'll repeat it. Supervised visitation, everyone, particularly everyone who's on notice, understands that it's the interference with a critical constitutional right. It is for the shortest period of time possible, and the court recognizes no financial issue or custody designations can be disturbed on appeal. But that everyone was on notice that if we're changing, even if it's just changing a supervised agency, the goal of a reporting cycle on a supervised agency is if it's sufficient.
You better leave my dog alone. Don't even pet my dog. You stay away from my dog. Monica, are you going to steal my dog? If you do, and you bring my dog back to the United States, I'm going to steal it. I'm going to steal my dog from you.
That the supervision would be lifted, and if the jurisdiction is improper to lift it, then there should have been a writ run on the issue of the referral in the first place, because everyone was on notice. We're not gonna continue to hold someone's rights hostage, basically. We'll keep giving us positive supervised visitation reports and do it for 3 years if that's where the appeal takes us. So the court
We are
can
the
will
only
lift
issues
it.
on
If it's
appeal are
erroneous, we
custody.
will find out soon enough. I cannot keep doing this cycle of supervision.
Respectfully, Judge, what have we done? We've not placed this at Your Honor's feet. We didn't
Pardon?
file the appeal. We haven't filed the series of litany of
I
motions.
know,
He simply
but it's
said
still something we're
supervised
dealing with
visitation,
here.
Ms. Hurd refused.
It's still
She
something
demanded
we're
that we
dealing with.
switch. Your Honor essentially noted that you'd really appreciate it if we'd agree to switch. I told you I thought
Okay.
there was a jurisdictional issue with that. I was very clear on the record at the last
Okay,
hearing.
I want to make it very, very clear, and I happen actually to have a fair degree of confidence how this particular issue has been resolved in the past. If there is an agreement and no one runs a writ or says any continuation of supervised visitation does violence to the issues on appeal, which it doesn't because the court's not changing any custodial or financial issues. If the understanding is everyone is on notice, particularly people with attorneys, that these report cycles are for the purpose of informing the court when we are ready to lift supervision. It's not for the absurdity of, even though the appeal could go on for 3 years, we're gonna continue to be supervised. It's to be lifted. The court has a very fair degree of confidence of how these matters have been handled. And if what you're saying is true, it absolutely would have mandated, no, we are running a writ on this issue of continuation of supervised visits. Because if you don't, and you allow a situation to exist where we're gonna get reports geared for the purpose of informing the court that it's safe to lift the supervision and allow some access, that everyone's on notice that that is the drill and that is the purpose of this. Otherwise, I would have to accept an absurdity that because something's on appeal, we're gonna keep, every 3 months, we're gonna keep getting a supervised visitation report saying everything's great, we should normalize the relationship, but I'm not gonna normalize the relationship because it's on appeal. These are not the situations embraced within it, and the court has a fair degree of confidence anecdotally as to how these matters have been handled. If you're right, I'm not gonna hold these rights hostage any longer. If you're correct,
Judge, I don't
That
want to
if
see.
you're correct,
I don't wanna see
then I
Ms.
will
Hurd's
know
rights
soon
held
enough,
hostage,
okay?
and
I'm not gonna
I don't
do it,
wanna
it's
see Ms.
absurd.
Hurd's- I don't want to see Ms. Hurd's rights held hostage, and I was very clear
Okay,
about
so
that
what
last
is
time.
the harm?
But I
Well,
said
okay.
last time, I noted for the record last time, Your Honor, respectfully, that when you made the change and set a status
Okay.
check, I said, Judge, I'm not certain
Okay.
what we can do and what the purpose of a status check is. I think it
Okay.
would make much more sense for Ms. Hurd to dismiss her appeal. I'd remind the court, her appeal is a
I
custody
already
issue.
dealt with her that.
It's
You
not
have to
even-
understand the impossible situation I'm in. She won't, no matter
know
what
you
I
are.
tell her,
I know.
she thinks
I know
it's a
you are.
great
I know.
idea, and I can't really, I've told her what I
No.
think. I can't pressure someone to dismiss an appeal. I can advise her, get advice. She says she's gotten advice, which I find hard to believe that anyone who really knew this case, a competent lawyer, would have told her that this is effective strategy. But she's telling me she spoke to someone who insisted that she continue with this approach. I've interfered as far
I
as
appreciate
I
it's a
can.
different-
And the court has made it clear. And I do think, without directly addressing, it's like this is being minimized, like, oh, we were just being cooperative, and maybe you were, so we let this go ahead, or we changed the supervision, or we did this, or we did that. It doesn't matter. You have to aggressively and very clearly deal with this core issue with authority and with a writ, that if somehow that's wrong, that this wasn't intended, since no one objected to it, and no one did issue a writ, and it ran forward with the purpose of a supervised visitation, everybody knows that is for the purpose of making sure children or a child or children is safe. An appeal or no, the court is not going to continue an artificial restrictive situation like that if the crisis has passed. So unless Dad is submitting some compelling material or witness that there's a direct issue of harm, I think these hyper-technical distinctions are not helpful. And candidly, the court thinks it's on the right side of the hyper-technical distinction. I am extremely confident. If I'm that wrong, you should be really eager to get this slammed in, reversed in a minute. Because the fact of the matter is, the proper way, if this was, oh no, you need a honeycut carve out, this is improper, then the attack should have been, the challenge to begin with should have been, where no more supervised referrals, no changing of supervision, no stipulations, no supervisions go forward, because it's understood this issue has been dealt with very narrowly by courts. The understanding is that if the court has jurisdiction, despite an appeal to order supervised visitation, it has the ability to lift the supervision if the factual crisis seems to have passed, or the situation which led to the supervision is no longer in effect. And this is ignoring, to say, oh no, everything's is frozen, ignores the fact that child support, despite appeals, continues to run. And
CJ, I hope you didn't leave yet. I was getting coffee. I hope you feel better soon. We miss you, CJ.
visitation continues to run. And yes, visitation can be modified when appropriate, particularly to lift a supervision despite an appeal, as long as the court is not doing violence to the custodial designation. Child support, because of constitutional and public policy reasons, and also the lifting of supervision for some basic constitutional underpinnings. If that's wrong, we will find out. Otherwise, I'm not
I'm
going to
not
engage
interested
in
in
this
proving this
absurdity
court wrong.
of every
I'm
3
not
months saying,
interested-
sorry, Mom,
I'm not
no matter how
interested in
well
proving-
you do, you don't get
You're not gonna let me-
visitation
you're not-
except
Your
an
Honor,
hour a
let me
week.
make- Your Honor, I'll be very brief, but I do need to say. no
But you
one
haven't
wants to-
addressed specifically what the court's no, never mind.
No one's attempting to prove this court wrong. It would be a Pyrrhic victory to do so. My client stands to gain nothing, A. B, in our view, Judge, she had supervised visitation. She simply requested to change the identity. If you believe that somehow required us to go up and file a writ in the Supreme Court.
I absolutely
lest
do.
we be-
Unless there was a
Okay,
violent,
that's
because
fine.
everyone, yes, because everyone is on notice unless you ask specific findings, and I told you how these things are handled in the past. Unless there's specific findings that the situation is so terrible that supervision needs to remain indefinitely, and we don't need periodic reviews, and we don't need periodic reports, common sense-wise, legal-wise, procedure-wise, constitution-wise, it's for the purpose of normalizing a parent-child relationship if a crisis has passed, and she's not.
Then Your Honor,
She's not
I've
going to
always-
get.
Your Honor,
If
could
he's
have
off
always
on
made that
weekends, she's
change.
not going to get every weekend. If there's a problem, he just needs to be back in court. If he thinks there's going to be a problem and a crisis, we can save him the money and time of emotion, and we can set a status check on this as soon and quickly as he wants. 1 week, 2 weeks, a month, but I'm not gonna continue with this approach.
Okay.
Now, that being
Judge,
said,
you made the record. I'm not
is
going to
that
argue
being
with you. I
said,
appreciate the
you know, when you
concern.
dismiss an appeal, you have the right, I believe still, to dismiss it piecemeal. If you want to continue with some financial issues, but you want the court to be able to fully address any and all issues concerning a child, including if you dismiss the appeal relative to your child, that would invest the court even with the ability to deal with custodial matters in the future. I don't think we're vaguely there yet. I just think it's a matter of normalizing. Too much is being made of a short.
She gave them all this problem. This is all her. She's like a puppet master.
Contact time on the weekends without telling me what parade of horrors are going to ensue. And if people are really concerned about the integrity of a record for appeal in this area of law and custodial matters, you know courts of review want to see it all over the place. Okay, you identified your technical argument, but if your technical argument is someone's rights are held hostage to a child for a few years, don't you want to tell us why that's justified due to some super danger? Otherwise, you can expect courts of review in this area of law far more often than not to issue child-friendly orders. And
Do you know what's crazy, guys? We've been through 31 minutes, and the mother has only spoken, like, what, twice? And it's all this craziness going on. The mother's not even talking.
and parent-friendly orders as long as children are safe. So with the understanding, I still don't have an answer of whether he's off on weekends.
He is off on weekends, Your
Okay, you can't have the whole weekends, he's off on weekends. And we gotta start slowly, maybe Saturdays 10 to 6 or something,
I'm
and see how
perfectly
it
okay
goes.
with that.
Pardon?
I'm perfectly okay with that.
Okay.
My knowledge, Your Honor, the matter on appeal is simply a custody case. As to Your Honor's queries about
Uh-huh,
financial issues, it's not a
Right.
divorce matter.
right, and for the
Your Honor-
court,
Your
the
Honor,
court
will-
has made a clear record
I am
that,
Groot.
that child support and enforcement that's not affected by appeals, nor is the lifting of supervised visits if there wasn't a writ run on the issue of continued supervised visits, whether it's changing the location or just continuing the concept in general, which we do have. So, what is so horrible about, maybe Dad'll get a lot of information, maybe he'll see, the only way for him to learn, arguably, to have a lot of his concerns addressed, is if we take a chunk of a few hours, and then he's gonna know some of my concerns still linger, or he may say, things aren't as bad as I thought. But no matter how much money we spend and how much years we go, he's not gonna have his concerns
She's
addressed
adorable.
unless we start implementing matters, and I don't see any immediate a danger issue. So she wants to start Saturdays 10 to 6. Now, for starters, if you want a status on that, now with all this going on, are you gonna
Oh my God, is that Groot? Oh, I didn't even notice.
get some further advice? Because if this wasn't clear at the beginning, with my frustration, I don't like to ever be in a position to tell people, and I don't, ever, except about what to do with appeals, except when every problem I'm having ruling in someone's favor is caused by the fact that they didn't have an attorney and they thought that it's that, because life is not that simple. It doesn't mean you appeal something and you get a decision down the road reversing it, and in the meantime, you can come to court and do whatever you want. There's very little you can do when you appeal something. You can't ask, do you get that concept now?
Yes, I fully understand, and
Okay.
I'm okay with the Saturdays 10 to 6. I know what is going
Yeah.
on, and I know that is all I
And
can
be
have.
prepared, if they file appellate papers on this issue and they put you on notice that they're going to, if they do, it
Are you sure that's Groot? I didn't even notice.
might be very smart for you to leave, and if you want to leave in effect your appeal on financial issues, that's fine. But if you really want this court to work on these issues, even up to and including custodial rights for you, or half custodial rights, full custodial
Now
rights,
it's Iron Man. It's Iron Man monkey. It's a monkey Iron Man. Yes, we know it's Groot. Remember at the beginning of the video we were all talking about how it's Groot? And even Bren said, I am Groot. We covered it. We know it's Groot. The second one though, we don't know who that is. Or it's just a monkey. Space alien monkey.
anything can happen in a case or a child's life over the course of months or years. If you want the court to be empowered to do so, you can still maintain your appeal and say, pull all child issues out of the appeal. If you have some financial or property issues that are in there, but pull all custodial/visitation issues as to Ashland out of the appeal. I'm not telling you what to do or what not to do, I'm just telling you the basis of the law. The court thinks as the furthest it can possibly go, and I told Mr. Friedman the reasons why I think that it's proper. He believes it's not, and he's gonna put you on notice that if he's gonna challenge that. And if he does put you on notice that he's gonna challenge that, then you've got a decision to make. I can't advise you, but it would appear that if you really do want to continue to fight for custodial visitation rights and to have the flexibility to do so, don't take action where you disempower the person who's to make decisions. You take away 99.44% of their authority. So if there's some horrible financial inequities which occurred as a result of this, and that could be, I haven't done it, it's been a while since I did a deep dive on the original decree or order, there could be some
Oh my
important
God.
matters to
Holiness.
correct. But then that would be the situation. Now what's of interest though, is the two of you were never married, right?
No.
So how many property or financial issues, aside from possibly a child support issue, could really be at issue? Is the
Had your
appeal mainly
wives.
about the custody situation? Because what property or financial issues of huge magnitude could there be except for some child support orders or arrears or other financial orders like insurance or tax claiming or whatever? What could really be going on?
It's minimal.
Okay. I
was
don't
my
want someone
suggestion, Your Honor.
dismissing an appeal because I suggest it, but if I suggest it, if that's what's needed to get you the help you need, because the reason, I'm not upset with Mr. Friedman, although he may think I am because of the tone I took. I'm upset because we're having this debate about what I can and can't do, and someone's caused that situation, namely you. I'm frustrated because it's only these really, really narrow issues that I think I'm able to proceed on. Mr. Friedman's convinced the court can't even do so, and you may be facing an appellate immediate writ on that, which you'd have to spend a lot of money and time
I saw Mr. Taylor Swift play today.
to respond to, and writs are a lot more difficult to adequately respond to than appeals, where you have more time and they give you guidance. You missed this filing or deadline, correct this or that and get us this or that by this date, or it's dismissed. Writs, there's no room for error, there's no time for error. No one's gonna send you a lot of courtesy notices back saying this is the third time we told you to get the headings correct or how to paginate or format the thing. It's rough territory. So I told you to go to an attorney, and you said you did but can't afford them. I'm a little mystified that you're saying you went to skilled, experienced attorneys, told them the whole story, and somehow they thought that you can forge forward with everything you want on visitation or custody and maintain the appeal. Someone told you that?
I've gone to an attorney, I've received appropriate counsel, and
I may take issue with the.
No, I didn't get to
appropriate
see
part
her
of
at
that.
all.
If
I
you're
was
saying they said this is a great
working.
idea, you can maintain that appeal and keep pushing forward with anything you want visitation or custody wise. So maybe
That's
maybe
fine.
they didn't get the whole story, maybe you told them what you wanted them to hear, and not every single thing. If you provide someone every single thing that occurred in this case, and they consult every scrap of paper that's been filed, they review every video which is available, I think then you're in a position where you really are gonna get some sound advice if someone's willing to look into it, you know? I think you should ask someone to look into it. If you have to pay someone a little bit of money just to review everything in the case and to give you a strong advisory opinion, it's probably the best little bit of money you ever spent. If you can't afford to hire them to represent you, hire someone to provide a legal opinion, but make sure that you get in writing that they are gonna review every document ever filed, review every hearing in the case, and then I think you can probably soundly rely on it. But it's not that these people you consulted are not talented, is someone could be a genius, but if they don't know everything that's been done in a case, it's kinda hard to render a competent opinion. But you're gonna take that advice, it appears, so that's good. Now, Saturdays 10 to 6, where do we pick up and where do we drop off? Now, if in the meantime they tell you, hey, we're filing this or that unless you drop that appeal, you may have a problem. But if they say to you, nah, my client's gonna take a leap of faith and see how the Saturdays go, they'll probably tell you that decision over the next few days. So, assuming though, perhaps erroneously, that they say, okay, we'll take a leap of faith and see how the next week or two go, where would you pick up Saturday at 10 and where would you return?
I would request at my parents' house, that way there's at least some supervision over the exchanges themselves.
Okay, Mr. Friedman, would there be any problem with that? With the understanding you will tell her in a few days what your plans are, but if your plans were to let a visit or two go through before you file any appellate writ or anything, if that's your decision, would it be okay if it's at her folks' house, or does your client have a different preference?
I would love to be able to confer with my client, Judge, but we're in two different locations. If the court will permit me.
Do they live far apart?
No, we
But-
only live about 2 miles away.
If he wants you
She's
to come
talking about
to a place close
parents'
to him, is that all right?
I'm fine with that.
She's fine if he designates a place, and I understand this doesn't box him into anything. This is just so we have some orders in place.
To be clear, Judge, because a moment ago
In the event he selects the option of not continuing to finance an emergency writ, in the event he selects the option of proceeding forward, then you don't have to file with the court for emergency help. You already know what to rely on. So if it doesn't prejudice his rights in any way, shape, or form, it's just that if he
Anthony, please stop. Do not say things like that.
selects to let this go forward, so that people at least know where to show up. Where do they show up?
just so I can be clear, Judge, what you just said was meant to, I guess, contrast from what you felt that didn't occur last time. Because I'm concerned at this point, you've deemed my prior comments on this issue, and I don't want to belabor it, but you essentially said that my prior, despite stating that there was a jurisdictional issue, somehow I needed to file a writ. And so by engaging in this conversation,
if there was something wrong with my tone, I apologize. I in no way, shape, or form specified it to this particular case, or said because a party or an attorney agreed to this, or that, and that they shouldn't have, and that strategically it boxed them in. It was in no way, shape, or form remotely meant in that sense. I was painting just with very, very broad strokes, saying generally, if we're dealing with a child support issue or a normalization of a supervised visitation schedule despite an appeal, generally the court has the ability to lift supervision if it's appropriate. The court lacks the jurisdiction to change the custody configuration unless there's actually appeals or writs directly with the issue of the supervision itself. So yeah, I stand by what I said, but I apologize if it sounded like I was specifying it to some action taken or not taken. Everyone did everything appropriately and skillfully in this case. I'm painting with much broader strokes as to my comment. And the same here, with just so we have full qualifiers in place. By agreeing to this, I already, in the question itself, indicated with the full rights to say, I don't like that, I'm taking appellate action. I'm just saying, if he, and he's the full right and ability to do so, and is
Are those English words? What does that mean? Is that a different language? I.
in no way abdicating any of that by this agreement. The agreement is not, again, here's where we're gonna meet Saturdays at 10 to 6, and I'm stuck. It's if I decide not to seek additional review remedies and I decide to allow this to proceed for a few weeks to see how it goes. With all those qualifiers in place, I just don't want them to have to spend a lot of money and time with some emergency hearing to work that out, because they didn't have it worked out. That's all. There's no hidden motivation, there's no landmines to watch stepping over, there's none of that. It's really just meant that simply. If he doesn't seek to challenge this situation at this point and he allows it to go forward this coming Saturday, I just need them, it's that simple, I just need to know how they're gonna effectuate. Unless they can work it out and they don't need that, I don't know.
I understand, Your Honor. I have the utmost respect for you, and it, I was just wanting to clarify because of the technical area.
I understand.
And I think you and I are in the same unenviable position of
course.
frustration where we find ourselves.
No, I don't have a problem if they're confident we don't need to belabor this point, that if he decides to let this go forward, he'll tell her, email her, or text her the location, that's fine.
So, Judge, the issue, so a couple things. The issue is that as far as communication goes, to my knowledge, Ms. Hurd is still not enrolled in the communications app, so they don't have an adequate means of communicating effectively, so I wouldn't
What
want
if
to rely
it,
upon
okay,
that.
whether it's never ordered or not, if it's ordered now, isn't it a good
It was
idea?
ordered.
We had this discussion quite intensely this last hearing, and Mr. Friedman fraudulently put it in the last order. You said let things go because we had a long discussion, we're already going way longer here. Never been ordered before.
He's
I'm not
fraudulent,
comfortable.
because he wants to help you to
No, he's fraudulent 'cause
communicate
he
more
put in a
effectively and
directive.
avoid conflict and
You put in
problems.
a directive that you didn't give.
Okay.
You said just proceed as we have been doing, which is texts and emails, because that issue is an issue that he also
Well,
filed a fraudulent TPO
Well, let me
on.
put it this, well, the TPO aside, if he
We
puts
can
some,
text,
okay,
we
hold
can
on.
email.
I want you to understand things proportionately and with nuance. If someone put in something that they get 40,000, they're not entitled to, that's fraudulent. If someone mistakenly put in that you two are gonna employ something which costs little or no money, which helps you communicate and parent more effectively, and there's no malicious motive, and in fact, there's an altruistic motive, and it just happens not to have been ordered by the court, but is standard fare in most cases, I'm a little concerned
We had a
that you would,
discussion about
that you
that,
would
Your Honor.
view someone wanting parties to communicate better and resolve disputes better, that you would view that as fraudulent simply because you believe it may not have been technically
We discussed this in detail
ordered.
last time, he gives his password.
Are you
login
listening to what
his
I'm saying
girlfriend
here?
and
I'm
email.
saying forget about what he does or doesn't do. Do you really wanna interpret, I think I didn't make the point clear, it's not a legal point, it's more of a behavioral psychological point. You guys are gonna continue to have great difficulty with everything in life if there's such a suspicion level where even if someone does something innocuous that seems like it's for the benefit of a child, that we get suspicious and assume they're trying to commit a fraud. I made my point, it either sinks in or it doesn't. So he, I don't seem to have a response from either of you about where you want to.
Well, Judge, not taking care of this issue right now is going to bite you in the ass later. Yes, it is.
Meet on Tuesday, 10 or 6. So I don't
I
want
was
to ask
trying,
it, I
but
don't
I
want to
can't
ask
seem
it
to
in
get a
ninth
single
time
word
and be
in,
in
so.
circles.
I asked
So
this on
if you two feel comfortable working it out, which Mr. Friedman is saying, how do the two of you communicate if we're not on the app? Well, let's deal with that.
We can
How
do
do you
text-
want to communicate?
Text messaging.
Have you been texting?
Yes.
Okay, if you can effectively text message, we'll relax the parenting app or not require that, as long as all text communications, no one argues with anyone, it's just simple factual matters. Okay, so do you know where you want to meet Saturday?
Yes,
Francis?
like I said before,
Your
my
parents'
parents' house.
Okay. Mr. Friedman, how long will it take to get a response back to her about the location?
My preference at this point, very respectfully, Your Honor, and I mean it with the utmost respect for you, just order what you're going to order, and I'll address it with my client. I'm really not
Okay.
interested.
You see, the problem is, I don't think, I candidly think that's, there's such a thing as being too careful. When a court of law says, 1,000 times in a row, it doesn't prejudice anything and all rights are there, which you can't say was a
I
representation.
can't get a
on the
word in
supervised-
edgewise, Your Honor. I
on the
was trying to
supervised
ask my.
visitation, the court did not say it's never has jurisdiction to lift the supervision. I'm just trying to avoid problems for them. It's not going to occur if we can't agree on where it is. Even if your client decides, I want to let it go forward. If we don't know what we're gonna do, now, if you're, okay. If they're insisting that I rule, because they don't want to
I
agree
was
or
just
cooperate,
stating,
anything,
Judge,
I get,
I
okay,
couldn't
fine.
get
What if it's
in.
a place if the court were to rule, and he doesn't, because I don't want to phrase it this way about the
I'm
court
okay with
ruling.
exchanges
So let me do it
happening
this, since that
anywhere.
seems to be a big thing. Where would he find it most convenient for him?
We only live a
Yeah.
couple miles apart.
I
I'm
know, that's
okay
why
with
it's a big-
exchanges happening anywhere, at Starbucks down the street, at the park, at McDonald's, I don't care.
Okay, you heard what she said, Dad. If he's concerned about stipulating to anything, then the call of the question is, he's not stipulating.
I
he's
like
not
the judge.
He's not stipulating, he's just answering a question of the court about what's most convenient
He's
for him.
frustrating.
And the court, perhaps against his will or her will, with all rights reserved to attack something against their will, is issuing an order. What would be convenient? I can't qualify it any more than that, and I'm not gonna leave
Your Honor,
them
I
with the
wasn't
absurdity of
asking
not
you
knowing
to,
where
I
to
just
show
was-
up.
I
Pardon?
just couldn't get a word in edgewise. The reason I addressed the parenting app was I was about to, if I had been able to get more than a sentence out, say to my
First of
client.
all, why would you want to argue that after what I told her?
Arguing it,
After
Your
I
Honor,
just told
I'm
her that
literally.
you were acting, that you were trying to help, that you're trying to help with this, and that you're trying to help these people save time, money, and aggravation. So I posed that question to her, why would she challenge something that you did, which was for the benefit of them and the children? So why would we want to keep belaboring that point? I told her that the way she designated and characterized what you did, I found was pretty outrageous, because I said, you were just trying to facilitate the communication. You were doing something for the benefit of them and their children to save aggravation and money. If that's really insufficient, and we need to keep talking about that, that's fine, go ahead.
Your Honor, what I was saying was if I had finished the sentence about that, my next sentence was going to be to ask Mr. Opapari, since I couldn't communicate with him offline, if he had a preference, but I was unable to get there. That was all I was trying to say a moment ago, and that's all I'm trying to say now.
Okay.
So since you're here,
Where
Mr.
does it-
Opapari,
where does
you've
he
heard-
think, if he thought an exchange should be that he doesn't agree,
asking-
if he thinks a visitation order which he doesn't agree to and he may attack, if it does actually occur for whatever reason, what would be convenient for him?
I was just trying to ask him that, Judge. So,
Okay.
Mr. Opapari, obviously we're on the record. You've heard all of the reservations that the court's made and all of its statements. They're very clear to me. What I was trying to ask you a moment ago and again now is, of the litany of places inclusive of your home that Ms. Hurd suggested, was there one or is there one that is in the child's, given that context, best interest and mutually convenient?
Yes, exactly.
Mutually convenient would be Starbucks would be fine, but my biggest concern is the drop off at 6 o'clock, because in the past
Okay.
she's
What about something
Deliberately
that's
is
not
late.
mutually convenient, but just convenient for you, that she's willing until a return in 3 months, and we'll get a date on that to agree to? You said you'd agree.
Yeah, I will.
She doesn't mind driving to your neck of the woods, that's fine. So where would it
we
be?
live a mile and a half apart, sir.
I understand, but, so if you.
So the
if Star-
Starbucks was
okay,
located
so
where?
I get it, so that's why I'm getting aggravated, having a debate about a non-debate, an issue that. no one's
Starbucks was
disagreeing
located
on.
where, Mr. Opapari?
Okay, the
Can we,
Starbucks,
yes, and can we also talk about the day,
which Starbucks?
Which Starbucks?
College and Horizon?
You agree to that one, Mom?
Yes.
Okay, now as far as discussing the
Can we
date,
talk about the day?
she has off weekends, do you have weekends off as well?
Yes, sir, but she also admitted that she has a flexible schedule because she drives for Uber and Lyft. She
Well,
picks and
mhm.
chooses when she wants to work. And I have extracurricular activities that I do with
Oh my God,
Advent,
she
and we also
works.
frequently travel out of town
Okay.
on the
Now,
weekends.
okay, now, if his days off are set at weekends, but you have significant flexibility, Why can't we do just like a Thursday or something? Now, someone else may have to coordinate this if he's at work, though. We may
Because
have to-
that's what happens, is that it's his mom or his girlfriend, and I'm not comfortable.
Okay,
with,
well, you know,
going
guys
out
have to grow up. We
Also,
can't just have a
Thursday
list of
nights
everybody,
are extremely busy
someone's just
for me.
handing over a child. We can't do that anymore after all these years. I can't possibly agree to
I would
anyone
like
in
a
her
weekend
family
with
or
her.
his
I would
family,
like a
they're all
free time
bad.
with her, not a
Do you
school
guys
night,
wanna,
John.
does someone wanna start growing up? If we want,
Excuse me, sir.
no one's gonna agree that there's
Sundays,
anyone in
I don't
anyone's
care.
extended family who can hand a child over to someone else. It's always, that,
I would like more than 2 hours with her, and a weekend allows that. I would love
Guys,
to have some free time with my
okay,
daughter.
well, the fact of the matter is, that's not, because you guys can't identify someone.
He goes out of
That,
town
okay,
for
that's
softball.
not a good enough reason. It's a good an excellent reason if someone is off those days and that's their time off and you have a flexible schedule. So what's so hard about a Thursday or a Tuesday? Pick it.
Because she has school.
Well, there's that part's true. So should it be later in the day then?
She gets out of school at 3:30, Your Honor, when school starts.
Okay,
All
Well-
right, so we're gonna do a 3:30 to like her bedtime?
She can do,
seems pretty late. You wanna
I'm
give her
I'm
two
okay,
nights?
She's
okay with,
fine with that.
You wanna give her 2 nights a week?
Sir?
So she can get her back to you by 7:30 or 8?
I can
I'm
do
perfect with 4 to 8,
Then she
4
loses
to
a
8
couple
Wednesdays and Thursdays.
Oh, he's agreeing Wednesdays and Thursdays. Okay, now, okay, that gives you more time,
Okay.
okay? Wednesdays and Thursdays,
Okay.
4 to 8 each day. So Dad, you're gonna pick up from school, now wait a minute, what's your work schedule again? Your hours,
Mine, sir,
please.
8 to 5, Monday through Friday.
Ah,
But I do work for a family-owned company that's very open and reasonable with
so do you- 'cause
flexibility
it
of going to get my
appears that
son,
you're gonna
my
have
daughter.
problems if people designate other people. Okay,
There's no issue, sir.
good. So if can it always be you to pick her up at school at 3:30 on Wednesday and Thursdays and
I
deliver
only
her
wear
to
mine at
Starbucks
night.
by 4 and to rendezvous back at 8 and meet Mom there at 8 and pick back up? Can that always be done without you having to use, family help? I'm not sure what the problem with family help is, but I don't have 2 hours to hear about it, how someone can't
There's
get
no
money.
There's no issue on her with your family, and I have no
She
problems with
says
that.
she
I can
doesn't
guarantee I'll
want
be there to pick it
anyone
up.
in, she does say, for whatever reason, she doesn't want anyone in your family is gonna attack her, apparently everybody. Is that what, did I understand correctly?
No one's
He doesn't
attacking
have
you.
one
No one
relative
attacks
that
her.
isn't gonna attack you?
They've been very
No one
hostile
attacks.
towards me, and they've created in a very hostile situation that she constantly has to be, and I'm tired of her having to abuse.
Who is
me
she?
being
His
abused.
mom?
His mom and his girlfriend.
Okay.
That's
Dad,
false, Your Honor.
with that understood, with the flexibility you
Reduce
have,
this.
You're a wizard, Harry.
between now and the time we return to court in 3 months, can 100% of the time, are you able to do the 4 to 8? Or is there gonna be some emergency where you need a backup person who we're gonna have to designate someone who everyone doesn't hate? So, or are you
Your
able
Honor,
to do it? Are you able to do it each time?
I'm able to do it. I'll take my lunch if I have to at that
Okay.
time, but there's also, I'm in the automotive business, so sometimes things don't always go correctly with a vehicle.
Okay, so if, she's saying there may possibly be a problem on occasion?
On Wednesdays and Thursdays, it would be my mother that would be doing it.
Okay, she doesn't like your mom, she thinks your mom attacks her.
I have the same feeling about her mom, but I wouldn't mind if she dropped Aslan off either.
Okay,
Well, that's why I suggested my parents' house, and he said no, so that my parents could overview that, and we wouldn't have to have this.
what, so if he can't do it and his mom or someone does it, can they drive to your parents' house? We've got a 7-year-old, they can park at the curb, let the 7-year-old walk to the front door, right?
No, Your Honor.
Why not?
My daughter does have Down syndrome and
That's
doesn't
correct, I'm
comp-
sorry,
comp-
she
comp-
does.
comprehend not walking in the street at all times.
I meant just.
She's
to the
very
front-
smart,
I
but her
just meant to
comprehension-
the
her
correct to
comprehension
the
is-
front door with you standing there watching, or your mom standing there watching. Is she incapable of
Absolutely.
walking, like, if you told her, walk 10 or 15 feet to that door, would it be, even that wouldn't be
Yes.
advisable? Okay.
You could do that.
Okay, but if you think that creates a risk of some sort, then we're not going to. If no one figured out that after this hearing, if someone's sitting there, the last thing they said that we want to tell this bald guy up there, the scratchy bald guy, is that we hate everyone's family member, support system, and that we don't agree that anyone in their family, even if it means we're getting unsupervised normal visits, can simply
I don't think so,
pull
Fozzie.
up, hand child over, and pull away without drama. So you think if grandma hands over, if she hands over Aslan, she's gonna, even if dad tells her how to behave, that she's not gonna resist the temptation to insult you to your face? That it would be impossible for her
willing to go
to, as an
forward and
adult,
see.
a middle-aged
I'm
adult, she
willing to
couldn't
see.
comply with that.
I'm willing to go forward and give this a chance.
Okay, she's willing to give it a chance, Dad, and that's great, and I thank her for that. But with that said, try to always be the one, if at all possible. And if you're not gonna be the one, can you give her a heads up and send her a text or email and say, my mom or my sister is gonna handle it this afternoon? And then call your mom and sister and say, don't say anything, just smile, hand over the child, and hand over Aslan, and even if you say something to the mom, or the mom or sister says something to you, the court order is you don't respond, you walk away. I don't care what vile name someone calls someone,
fine.
they walk away, then you make a note of it, someone calls their attorney, or they tell the court at the next hearing. All right, so we at least have something which can work out, and they agreed on the Starbucks, if we're proceeding with this, and unless there's some intervention of some further legal proceedings, but if there's not, at least we have an understanding here. So, what's our 3-month return, please?
October 17th at 11 o'clock, please.
October 17th at 11.
I don't have that hearing, so maybe it was canceled.
And on the referral form. Mr. Friedman, will you be so good as to prepare the order, and you can put, obviously in this instance, you can put in the order, in fairness, put all the qualifiers you like. You could even include all your arguments and statements, whatever's necessary, whatever is on the video. If usually the orders are just the orders, and if it's a custody trial, if it's a trial or evidentiary hearing, usually the findings in the orders, and we usually don't get too much into the court said this or the attorney said that. But in fairness, I think if you want to place verbatim everything on these issues that you said, and you can obtain a transcript, and if you want everything that was said about lifting the supervision, if you want those in the orders, word for word verbatim, that's absolutely positively fine. In fact, it creates a much better record. But that being said, we also want it understood that if someone doesn't pursue that type of remedy, we want to start seeing something meaningful and rational happening in their lives. So, would you like to take a stab at your office preparing the order then?
I'm happy to do so, Judge.
Your Honor,
Okay.
can I request I get
And
a
if you
copy
want,
of
and
that?
again, if you would like that material in the order, just mention it to the court, and that's fine. Then we'll know it may take a little while for the order to be prepared. You want to?
I think
include all- Okay.
Can
In
I
an abundance of
request a
caution,
I'm
copy?
sorry, Mr. Freeman, I didn't hear that.
Thank you, Judge. Thank you, Judge. I think in an abundance of
Okay,
caution,
perfect.
make
I
sure
request
it's in
a
there.
draft copy
Can I
of
make
that
one
for
final
this
comment,
Sure.
Judge, before
Yes.
Your Honor indicated the enforcement of child support and payment of child support, you similar to these visitation issues, due to be within the court's purview. We raised at the last hearing the notion that Ms. Hurd obviously has not filed a financial disclosure form, isn't tendering any type of financial support. She's obviously representing now that she's working. Can we get a date certain by which she will file a financial disclosure form?
Just like even more so than the supervised visits, there's even far more clarity on the issue of support. The appeal has no effect on suspending support. So they want a new
FDF?
financial statement with your
FDF?
last 3 paychecks with year-to-date earnings, so that they can start on this issue of support, so that when we return to court, we can establish that, plus retroactively, apparently, is their request. So how long do you need to get that form in?
The FDF,
Mhm.
2 weeks, please.
Okay. And Mr. Friedman, you are asking for the last 3 paychecks attached to that. Also, did you file taxes for last year? Oh, why not?
I'm an independent contractor.
Oh, okay, all right.
So I'm self-employed. But, Your Honor, can I also reiterate, can I get a copy of that draft order before it's submitted for signature?
Well, I don't have
Self-employed people do have to file taxes.
I don't have a problem with that, but except for one thing. when attorneys get the draft order, they understand it's not a question of whether they agree with it or not, it's just a question, does it correctly reflect what the court
Right.
did? That's why generally, when people are unrepresented, I tell attorneys to submit directly, because there's a few protective layers here, where before it's submitted to the court for signature, we know it reflects what occurred. So the problem
Then the lawyer will be jumping over the bench. The lawyer and the judge would go at it.
is, if it's sent to someone representing themselves, they may think they're empowered to say, I don't agree that the court did this or did that, so I'm not gonna sign it. But that's not what the exercise is about. It's, does it correctly reflect
Right, I get
what the court ordered? And as long as you understand that, and you get it back to Mr. Friedman within 5 days with your signature, and if you don't sign it, then he can submit it directly with the court. I don't have a serious problem with that, but I can't leave it with you for 2 weeks or a month or
That's fine.
something, okay?
5 days.
All right, so Mr. Friedman, you can send it to her, but if she doesn't return it in 5 days, just submit it.
Understood.
Okay,
And so the due date for the FDF would be 2 weeks from today?
Mr. Friedman, she's asking for, we're not back for 90, she's asking for 2 weeks on that. Is there any objection to
If
that?
that's your honor's order, we have no objection.
It's, I mean, it seems reasonable, and 30 days or 60 days probably isn't, but 2 weeks on an FDF generally is, should have been handled a long time ago. But, and then, because you appreciate the fact that the key, the most obvious thing that's not affected by an appeal, we discussed the supervised visit, but much, much more, 1,000 times even more clear than that, because it's in repeated decisions and statutes. It doesn't affect child support, that still flows.
Same.
Otherwise, every time someone didn't like paying support, they'd file an appeal and jam the other side up for 3 years or something. So you understand that that has to flow. Have you been sending them anything?
No, that's also an issue on appeal. All the issues are up on appeal,
Okay.
but I'll do the FDF.
Okay,
and we can
but yeah,
proceed.
but as we've explored today, appeal isn't gonna do you any good about a
That's fine,
support
I'll do the
obligation.
I'll do the
Yeah,
FDF and we
yeah,
can go from there.
okay, you're gonna owe them something. What did it, now, if you're doing Uber, are you mainly doing Uber?
Yes,
Now, if this is something that doesn't really lend itself to the last 3 paychecks per se, if it makes more sense to, if you have that, that's great. If instead they would benefit more from an itemization of each date, what rides you had on each date and what you received.
As an
Mr.
independent
Friedman,
contractor,
what
I
would
have-
be the most beneficial
I have
to
a
your
profit and
side
loss
on this? What would
statement
make
I have to
sense?
fill out.
She drives Uber, I'm not sure me telling her to submit the last 3 paychecks is gonna make any real sense. So do you want some sort of itemization, or how do you, what would make sense?
Yeah, Your Honor, thank you for asking. My position would be both. I believe Uber and Lyft are at issue, but if she gets documentation from Lyft that there's nothing, fine. But I believe both of those companies provide reconciliation reports to their drivers, and that's how they reconcile payment to them. If she can just provide us, let's say the last 3 months of those reconciliation, that should give us an adequate picture of her current income. And then to the extent that obviously the litigation goes forward, if we need to, and we have to issue subpoenas from there, we could. But I think at this point, if we can just get 3 months worth of the reconciliations from both of those
And that's
companies,
fine,
that would
but
And you can
That's
provide,
not
I know you
taken
knew
into
one of those places
my
had the
bill.
reconciliations. I didn't know both did, but Mr. Friedman's confirming they both
And that
did, so-
shows what I'm getting paid from them, but that doesn't show my costs and income. I have to take out gas, I have to take out maintenance, I have to take out. So
How
an
about if
independent
you send, how about if you send the
contractor,
That's the point of-
reconciliation statement and then you have attached worksheet saying, for this period where I earned
Right. I would do a profit and loss
$580,
statement.
please be aware maintenance was this, gas is that, and then you can show that you subtracted that from the 580 during that period. And then they'll react to whether they think that's appropriate reduction or not, and they'll tell me about it at the next hearing.
All right.
All right? Good, thanks, everyone. Thanks so much.
thank you.
Okay, we made it to 2024, guys.
Very good.
Yes.
Okay, go on the record, Party versus Hurd, D 622669. Let's have appearances, please.
Matthew Friedman, Your Honor, 11571, on behalf of Mr. Okari, present in the courtroom. To my right, with me today is also my paralegal, Tracy McCall.
Excellent.
Kimberly Hurd, self-represented.
Okay, who's
And
the young
this is
lady
my-
with you?
oh, go ahead.
I'm sorry?
I'm Melissa, I am here for support.
I'm sorry? Her?
She's here to help me with all this if that was okay.
Okay, but if she's gonna assist you looking through records or finding documents, making notes, things like that, that's fine, but you have to be the one to
Okay,
present
Melissa,
that.
Melissa Sutton.
I'm sorry?
Melissa Sutton is your name.
Right, but you have to be the one to present. the
Yes,
act-
okay, that's fine. Thank
All
you.
right. Okay, now, obviously it's sort of a unique situation, so I think to be clear where our starting point is, since it reverts back to where the orders, if any, stood prior to that hearing that was challenged, what were the existing orders, if any? That was the ultimate custodial hearing, I believe, so do we revert basically to having no ongoing or no permanent orders? I know we are gonna track.
So I think as long as she doesn't talk, then she's not practicing law. So Kimberly's allowed to talk because she's per se. But Rebecca or Stacy or whatever her name is, she's not allowed to talk. She's not allowed to say anything. She's allowed to help her, give her papers, and that's it. That's it.
Track what was occurring with the Donna's house visits and fill ourselves in on that, but where do we revert to from your perspective in terms of with the existing orders, so we know what standards of burden of proof?
Judge,
and
that's
all?
it, and I appreciate you starting there, because those are some of the same questions I have. So we're here, as far as I understand, on remand from
No, sir, you don't get to talk. Anthony, thank you so much. I appreciate it.
the Supreme Court. And what the Supreme Court did was reverse and remand for findings consistent with the evidence that was already entered at trial, right? So there are, I believe, 50 or 51, 56 exhibits that are already in evidence, that are part of the record. A trial was held, the court, that was reduced to a final order in the form of a custody decree, one order after hearing. And appeal was taken from that, and obviously the Supreme Court's direction was, in light of the recent case regarding Soul, they felt there were some additional or heightened findings Your Honor needed to make if you intended to keep that order. Alternatively, you could enter an order, lessening something from Soul, for example, primary and joint, primary to my client, joint legal custody, something like that, and make those findings. And so I appreciate you starting there, because my question for Your Honor is, what is it that, how can I assist Your Honor in getting where you need to go to be consistent with the Supreme Court? I don't believe, Judge, and I think given the way this case has been litigated and the amount of time that we at least have, I don't know that we just, the court did not order a new trial, right? It's not that Your Honor can hold whatever proceeding you want. I can go through what's already in evidence. If that would help Your Honor to make the findings that you needed to make, certainly what we did is we did obtain all of the updated medical records for the child from the date of that order, and we've produced those, and we have those. Obviously, we can go through them. I will proffer you as an officer of the court. They're going to show you that it's just routine medical care. The child's seeing all of her specialists, she's seeing all the doctors, and everything's proceeding, as it ought to be. So, kind of from my perspective, I'm hoping for Your Honor, you can tell me. I know that, Ms. Hurd filed at like 11:30 today, pretrial memorandum. Obviously, there's already a pretrial on file from the trial, right? That we didn't file a pretrial for something that's already there. And she seems to be asking for sole custody, sole legal, sole physical custody of the child, and a slew of other things. And so, to me, I think there's a little bit of a disconnect in terms of if that's the case.
Who else is shocked that this guy gets to talk this much? Shocked?
And I don't know that Your Honor set this down for her, like a motion to modify. So I need some direction from the court so I can best use your time, best use my time, not waste time, and understand how I can help
So
you.
she's asking for sole custody, even though that's the exact issue that they agreed with her on, that should be a rare case where someone gets sole custody. Well, never mind.
Yeah, that's my reading, Judge. So you say, all I'm trying to say to Your Honor is I just need to know, it appears to me Ms. Hurd's request required an inordinate evidentiary burden on her that she would need to meet, because in the first place you've got to deal with the trial that happened and all of the various evidence, documents that are already in evidence showing best interest at that time, right? And then now it seems we're wanting to do something radically different. And candidly, the only information that I know Ms. Hurd continued to disclose a slew of things up to even today, I don't know if I even have binders, we weren't provided them. Do you have binders from there?
They're all delivered this morning.
To me, except for us?
I was told to deliver them here.
So you have mine then, okay. So, I don't know what she intends to use of those, I don't know what, but again, that's what I'm trying to understand. Because to me, and I kind of said this when we were here last time, I think the court was looking for findings relative to what came into evidence that day. And again, 56 documents and evidence. Certainly if you wanted some testimony from Mario or some testimony from, Ms. Hurd about those, the documents already in evidence, we can do that. That would assist Your Honor in making whatever additional findings. you
It
need.
sure is.
And if Ms. Hurd believes it's prudent to look at, the voluminous amounts of medical records we went out and got at my client's expense and produced, showing all of the ongoing medical care, we can do that too. I just don't wanna see, I guess, judges turn into 18 days of your docket because we're just kind of going on and on when we have very narrow scope of what the court wanted us to be doing here today.
Yeah, it is true, it's ideally a narrow scope, but it's also challenging in the sense, like, where does this order put us back to? What burden? Arguably, it puts us back to where there were no orders and they're both starting on even footing. But on the other hand, how do we ignore everything? Neither of them, I think, has any earthly interest in ignoring everything that happened the last 3 years after the hearing occurred that she took the appeal on.
Trial was in
I think
2022.
we're 2010 too, and
So it's
the month was.
It was August of 2022.
So no one wants to, neither of them want to ignore what's happened the last year and a half, I assume, so I'm gonna allow both parties to,
Yeah, well,
including the supervised visitation
on Ms. Hurd's not.
report, which, the one, it began on 4/13/23, and that there were 12 recorded supervised visits since orientation on 4/6/23. Each session, on time and,
I don't know what it is. Elephant?
Interactions were appropriate with toys, books, training, seat, etc. And the mom helped with toiling and the child and helped with pull-ups. And only on June 15th, 23 was mom advised about something about an inappropriate skirt. I don't know what that's concerned. And she accepted the redirection and all visits were safe, appropriate, happy and without incident. Or that's
Your Honor's
apparently
aware
the
we
report
progressed-
that we have,
We
yeah.
progressed past that, right?
Right,
Your
and that's
Honor-
what my question is, from your perspective, then we'll hear from mom.
We-
Where have we been going
Your
since then?
Your Honor, even though the case was on appeal,
So they didn't get into this, but she was dressing inappropriately during visits, and they had to tell her not to dress like that.
when we discussed it at a previous hearing, Your Honor
Right.
felt that, once she had, there was a period of time from August 2022 till April of 23 that she was not doing any visits because she just wasn't complying with the court's order. She didn't engage in it. Then she did, and she went through a period of supervised visits. We were back in front of Your Honor. Case was on appeal, and Your Honor was inclined to get rid of supervision at that point, which she did. And you gave her unsupervised visits, and she's been having unsupervised
Right, that's
visits.
what I'm asking for the update on, because I know that was the Donna's House report, but I'm not sure what's been going on since then.
Yeah,
So,
so
since that was terminated in what month,
she
and what's
was
been
at-
going on
at-
since
at
then?
Family First was the original court order.
Right,
And then we switched it to Donna's House in April of 23, because she hadn't done any of those. So then April 23, she starts doing the supervised visits. She did them. We're not here to make issues about it. You mentioned something about a skirt or something.
I don't
Fine,
even know
we're not
what it-
making
I don't
any-
even know
we
what
don't-
that's
Yeah, we
about.
don't have any issue. There's no issue. We would tell you, supervised visits happened. And then Your Honor modified that order, and Your Honor gave her unsupervised visitation, and she's been enjoying unsupervised
what's
visits.
it consist of?
She has 2 days a week. Then we made some accommodations for the holidays, Judge, so we switched some days, but basically it's Tuesdays and Thursdays.
Okay,
Wednesday,
it switched
Wednesday,
to
Thursday.
Donna's House in April, how long did the Donna's House go on for?
Till July.
July? So these unsupervised visits have been in place since July?
No. Su-
Well-
Unsupervised, yeah, unsupervised visits since July. That's
Since
correct.
July,
Yeah.
okay. And it consists of
Wednesdays and Thursday,
what hours
blocks of time, 4 to 8 p.m.
each day?
Correct.
Any overnights?
She has done it overnight.
Okay. From your perspective, what's of interest, if anything, to report from
I mean,
those visits, if anything?
this is a high conflict case, but what I would say what Your Honor would be concerned with is every single visit has proceeded according to plan. There's been no
Okay.
withholding, she's had her time. When we were here last time, we discussed holidays, we made some, moved some of those days to make sure she had time around the holidays, and she did have. So,
No overnights have been attempted?
well,
And I understand that the parties didn't really have the guidance of proactive court orders while this matter's on appeal, so that you guys had to sort of negotiate some of this, and I get that.
well, actually, Your Honor, just to be fair, I don't mean, Your Honor ordered all of the things that happened. The matter was on appeal.
I
and
think there
so-
was a stipulation, though.
Well, there was a stipulation to switch from one supervisor to another because
Right.
Ms. Hurd had a problem with that supervisor. But Your Honor, it was Your Honor's orders to move it that way. And I understood, and I told Your Honor, my sense was the matter not on appeal? And I won't rehash this, but I felt it was on appeal, and Ms. Hurd had wanted to take the steps back in, December of 2022, or even January 2023, to come to court and say, hey, I've done some things, can we look at changing my time? I think it would have been perfect. It was just the appeal that caused the problem. But obviously, again, I come back to what did the court do? The Supreme Court didn't say, and because you mentioned this a moment ago, and this is what's very important to me, so I know what to do for you, and also so I can make sure that we're consistent with what the Supreme Court said. They didn't say vacate the decree, that's not a valid order. They said, we need remand to the court so that you could make additional findings relative to the specific evidence. So the decree of divorce in question, prepared by Ms. Crone, she was trial counsel, cited to various exhibits. So it would say something, for example, like, Mario is the parent most likely to allow frequent associations, and it would just say, see Exhibit 15. But the court noted, but it didn't say, see Exhibit 15, which is a document evidencing blah, 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 that shows this. So that's really what they were looking for, right? I don't think I'm misrepresenting.
Which is a
That's
little
what they wanted.
unusual that the court would go that far, particularly on a case where only one side's participating, but that's
Right,
well.
right. And I think, Judge, again, I come back to, I think it's because of the nature of when it became sole legal, which is what, because she wasn't here, that's what my client was awarded. That's, I think, why they did what they did, simply because the case law had come out and said we needed some additional findings if we were gonna do that. So, that's a little bit of the quandary that I'm in, is that I think you have 56 exhibits in the record, you had a trial, the trial proceeded, the court did not, for example, Ms. Hurd's appeal it was a denial of her due process rights to move forward with the trial, and therefore she should be awarded a new trial. The court did not agree with that, that's not what the court said. The court, did not in any way opine that Your Honor did not have a right to move forward with that trial and enter the orders that you did. They simply wanted greater specificity in the findings.
At this point in time, I guess a few is there obviously, she'll be asking, the two of them are not gonna have an agreement in what her custodial time should consist of. But if she's asking for more than he wants to accept, and that's why we're here, but does he have any objection to overnights, and if so, what would they be? And if he does have an objection, what is it that it's based on?
I think honestly, my client's perspective is, if we, instead of being entrenched in litigation, and that's all we're doing, if we were just looking at parenting, I think we certainly would understand we could move towards that. And that's been, from the first day I came in the case and it was on appeal, Ms. Hurd was making various arguments, that's kind of what I said. I go, the problem is, she wasn't at the time doing supervised visits, and so we couldn't progress to anything, and it was on appeal. I knew, just because I know Your Honor very well, if you put somebody on a supervised visit order, you would never do that in perpetuity. You would have done it, there would have been things you wanted to assess to make sure safety was there, and then had you had the jurisdiction, you would have come in and you would have moved towards probably something like primary physical custody to my client and joint legal custody. And you would have done reasonable visitation, and that's where we would have gone. And I think that the stuff that's already, the 56 exhibits already in evidence, Judge, it's glaringly obvious that that was the order that would have come out if but for Ms. Hurd not being here that day.
As
Right.
far as sole legal custody, which the court doesn't like sole legal
Sure.
custody orders, but the fact of the matter, it's parties who forced the court into it.
Right.
If I think we're not gonna have parties cooperating and they're gonna be not on the same page with medical education, and if we see anyone calling and undermining an
Right.
educational or medical decision and we can't have cooperation on that, then
Sure.
sometimes sole legal custody does go to the parent who has more of the time than the other, but we could, see where we wind up now.
I can
I don't
tell
know,
you,
I
Judge-
don't know if cooperation issues are any more of a concern than they were then. Maybe they are, maybe
I
they
can
are,
tell you
hopefully
that I've
not.
spoken with my client about what I believe was reasonable and prudent, and what I had said to him, I said, listen, in my estimation, regardless of how, in my view, how one-sided the evidentiary record would have been that day of trial, I think if Ms. Hurd was here, she would have been afforded joint legal custody that day. And I think that what would have happened is, if, to what Your Honor just
So
mentioned, there
then
were
we don't have
these,
to fight too
yeah,
much
if
about
there
that
were
then.
these nasty,
Okay.
you know, people canceling appointments, then you'd come back to Your Honor, and then if Your Honor had good cause, you might do something like a modified joint legal, or you might even do a sole, but you would give somebody the benefit. So that candidly, Judge, has always been my opinion, because this is what I do for a living, and people have joint legal custody. People who have had issues in their past or whatever, for whatever reason, doesn't mean that they, you know, when I first started my career, I remember I represented the guy who was sitting in prison, and he had joint legal custody. So I'm well aware of that. You know, and certainly does my client have some concerns given.
That was probably a joint legal custody, limited in terms of access to records
Right.
and all. I don't think anyone wants to
I wonder how many drug tests she has had. We haven't heard about drug tests since 2021, and we're in 2024.
rely on someone in prison to authorize this
Right.
medical or
Right.
dental appointment or this
Right.
parent-teacher
But
conference.
certainly to be
But I
able to-
understand what you're saying.
That's all, that's my point. So yeah, so absolutely, and so absolutely, I think to us, you know,
Okay, what I didn't hear, which means it's not a concern, at one point there was a concern, there is no concern about narcotics or anything at this point, are there?
well, so Judge, I would say it this way, there is in evidence already is a very, very, very well documented record of drug use.
At the
okay?
time,
For a consistent period of time, yes. And so, my client certainly is not making an accusation,
Okay.
because he doesn't engage with Ms. Hurd, and he has, you know, there's nothing specific that he's seen.
Yeah.
I think it was an issue the day that they were here, what, the remand that we're here on, that trial day, that was an issue. There had been a series of failed tests, and then, I think, like a week before trial, a completely skipped test, which is 12 days before trial, a skip test, that was a presumed positive. So 12, you know, the trial that we're here on remand for, Ms. Hurd would have walked into court with, I think, 3 different failed drug tests, and then a test that she just didn't show for 12 days before trial. So it is an issue insofar as if we're dealing with, you know, making findings about that, then clearly those findings exist. I think, and the court's made those findings. They already exist in your order. The drug tests are already in evidence. The missed test is already in evidence.
I guess it's a tough situation. The court's probably not gonna disturb those findings as to what existed at that time, but the court's planning to make proactive findings as to where we're at this point. And I get and you alluded to this, with appeals, it's, the evidence is supposed to be frozen in time as to the disputed date. On the other hand, it's folly and nonsense, nor would an appellate court tolerate the court ignoring what's happened in the last year and a half in the life of a child, particularly if some substantive progress is made and things are changing, which, as we've discussed, they are to an extent. So I think everyone wants to talk about and have the court rule on not just the past, but the current situation as well, I suppose.
I know. You see where I'm
Yeah,
at,
right.
too. You and I are in the same
Right,
place. I
yeah.
get it. I
Yeah.
can tell you, look, from the time that you had trial in August of 2022, from August of 2022 through, you know, when she first began engaging in April of 23, okay, there was no involvement. There was a lot of not, you know, she was supposed to use a parenting app, she wasn't using it. There was a lot of texting and calling. There was a lot of continued sort of bad behaviors and no contact with the child, because the order was do supervised visits to family first. She wasn't doing it. So you have nothing to demonstrate anything other than what was going on in my client's care. So for that, all I'm going to be able to show you, Judge, is all of the child's medical records showing that the child, and, you know, treatments consistently did with, you know, child's not been harmed, academics, health-wise. That's it. That's the record. Then what you have is a very limited record where when Ms. Hurd begins visits in April of 2023, you have a series of supervised visits that go. We change supervisors. Those go, I think it's 10 or 12 visits. And then we have some unsupervised visits, 2 days a week for 4 hours at a time. That is the entire, and then again, we can show you the continuity in the child's, care while in my client's custody, all of the medical, all of the dental, all of the occupational therapy, the speech therapy, we have all those records, right? Other than that, I don't know what evidence I don't know what, do you understand what I'm saying? It's fundamentally very limited in terms of, for best interest anyway, what I think Ms. Hurd can show, or certainly what else we could show you.
At
It's
this
not a
point,
situation that
he's not
we're-
reporting any problems with the exchange or anything, is he?
No, they're,
Some people get that from cats scratching or biting. Cats have this bacteria or whatever that affects some people. That sucks. That you need to get some sleep. Because there's no way you slept at all.
Or any
No-
purported neglect, anything?
no neglect, no
Okay.
abuse, no, obviously they're 5 minutes late, 10 minutes late here, whatever. No, nothing, the bottom line is, they've complied with the orders as you've modified them, and by and large, they've gone out without incident. There has
All right,
not-
let me find out from Mom what kind of schedule she believes is appropriate, and then the parties can put on their evidence or witnesses. Plus, if they want opening statements, although a lot of it may be duplicative with this lay of the land type questions I'm asking the parties now, but if they have new material for their opening statements, they can. Let me just walk through some, young lady, no one brought up anything about narcotics, so let's assume that's in the past. Are you currently working?
I am part-time.
Very good.
If I could, Your Honor.
Well, just humor
okay.
me with a
I
few,
have some,
I get it, just
statements that I
humor me with a
disagree.
few, background
Thank you.
questions so I know what
Okay.
we're talking about.
all right, thank you.
What's your, what type of work are you involved in?
I drive for Uber.
Okay, so it's an unpredictable schedule,
It's something I can do around
right,
her.
more to the point, flexible. Do you have any
Yeah.
other means of income?
Not currently, not
Okay,
right now.
do you live by yourself?
I live with my parents.
Okay. What do your parents work at?
They're retired.
So they're both retired?
Yes.
And they live in Vegas, or?
In Henderson. We
Okay.
live 2 miles from,
Oh, okay. So it's you and your folks?
yes.
Okay. Do they ask, to what extent, if any, do they, do they ask for any help or only as you're able, or do they have a set amount they ask for each month, or?
They don't have a set amount, it's just as I'm able, and then I particularly love to clean, so I keep the house.
So that
tidy
sort of
and-
compensates for it?
Yeah, so.
Do
and-
they ever
and
ask for a
honestly are
couple
helping
hundred
me out.
for groceries, or there's really no pressure?
We
long-
keep separate, like, they take care of their household, I take care of mine separately.
Okay, so, do you have a car payment, or is your car paid for?
I do have a car payment, it's in my father's name, so,
Does he take care of that at this point, or?
yes, he helps out with that, cause
Okay, what is the payment, just in the event that you do?
$900.
Oh, that's, what are you driving?
It's a Subaru,
Okay, and is he covering the insurance on it too?
yes.
Okay, do you have health insurance at this point?
I
Okay. Cap. Her car payment ain't $900 a month. It's just not. It just can't be. Who would give her a loan for a car with a payment of $900 a month if she doesn't have a job? Or is she paying a parent for this? Because if she's paying a parent this much, she is lying so bad.
do through, through the government assistance, because I was on the assistance.
Okay.
That's kind of in limbo because I haven't updated my documents, but yeah.
Okay.
And there's a whole lot more we'll need
We'll get to
talk
it.
about.
She's
So
lying.
obviously,
Oh my gosh.
this car is fully timely registered and up to
Yes,
date, as
yeah,
is
yeah,
the
yeah,
insurance,
yeah,
right?
Yeah,
As, and your license is certainly current, right?
yes, I've had background check and everything you have to for Uber.
Okay. What are your, if you know, what are your future employment plans, if any?
I would like to go back to school and get my master's degree
Okay,
and actually probably study for my LSAT.
okay. Okay, so that's roughly the financial or living arrangement at this point.
Yes,
And your folks are, in the event it becomes important, are your folks available to help with transporting,
yes,
Aslan, or does it depend?
No,
Are they
no,
in, okay.
That's fine.
What's their relationship with your daughter?
It's a very good and positive relationship. She really looks forward to coming over and seeing them.
What type of schedule do you think is appropriate between the two of you?
Your
Then
Honor,
Then you can tell me why, I just wanna know
okay,
what the schedule
I
is.
feel like, sole legal needs to be vested with one parent because there is no communication, and I feel it should be me because I am the one who's,
It's already been,
well, I can establish, I have an
you're
expert.
already, established in this case that,
There's a
sole
lack of
legal is pretty much,
communication.
gonna be a no-no.
All right, well, that's up to you. I do have, you, like the
Not,
last
that's not
hearing-
that's not happening.
Okay,
You're asking for the very thing that you found so inherently offensive. In
No,
other
not
words,
physical,
you
not
two
physical
parties are
custody, not
required to
physical.
work on matters. But we'll get to legal custody later, I
Okay.
get, and I understand, I don't wanna go down that rabbit's hole yet. The court will determine that later. But how about the schedule though, the physical custody, what
the
schedule? do you
physical,
want?
I feel like she should have primary because there's been an issue with toileting. She's still in diapers, and I have an expert that will testify to the fact that she should not be in diapers. She is smart enough that she could have very well been trained 2 years ago.
What schedule do you envision?
We're every other weekend, as it depends on her toileting because
Do you want
she's-
her in your care except alternate weekends?
Yes, because I feel it's imperative to her development psychologically and medically for her toileting issue, and she is being harmed right now.
It'd be
There's
sort of
substantial-
dramatic to go from, in a case where, to go from him essentially having her accept these 2 4-hour blocks for the last few months, to revert to alternate weekends, which would be a very limited amount for
And I
a
understand that.
secondary
That's why I'm an
parent.
expert.
You would have to convince the court that this is a serious issue,
It
that
is.
he's not only completely incapable of addressing, but also absolutely refuses to address.
I can do that.
Which could be the case. Tell me a little about it, cause she's 7, right?
Yes, and
And
that's why,
she's not fully trained.
she is with my care, in his care, she is not, and she's having issues. And I do have an expert that can testify to that has fully reviewed her medical, and that's one of
Okay.
the other issues I have.
Okay.
He's not taking care of her. 2 binders I could point out to you right
Okay.
now, is not him, it's his girlfriend,
Okay, I
So,
got it. What's
he's
her
advocating for it.
diagnosis?
Down syndrome. She has a diagnosis of Down syndrome.
And that's not in dispute from you, so, right?
No. But she is fully capable of being further along and being potty trained. In fact, she wears underwear at my house and she
Okay,
is potty trained.
what school does she attend?
CT Sewell.
Okay, and who's the pediatrician?
It's Anthem Hills Pediatrics. And her pediatrician that I had
Okay.
before this happened testified, and I have in
Okay.
the documents that she
I-
could
If you're
potty
going,
train
if
at
you're,
3.
if you're seeking, and I strongly advise everyone to dump a sole legal custody request, it's beyond ludicrous at this point. Unless, you can show that you sent letters to his attorney and emails begging him to appear before the pediatrician, the behaviorist, whoever, all these parade of experts, and they said, we told this to Dad, he refuses, and that and plus that he's incapable of it. Now, which I don't think we're gonna see, but more to the point, as a practical matter, what is it you want him to specifically do vis-à-vis this potty training, for lack of a better word, that he's absolutely refuses to do?
He's not training her.
What is it you've told him that you put
I
in
have-
writing and told him to do that he won't?
Back when we had joint custody, back in 2021.
Remember, I asked him these same questions about you. What is it she absolutely, and I
There's
was
no
just, and when I,
communication, and I can
when,
show
and I made,
extensive-
and remember, and I made him say, show in writing where you told her these are issues.
I
We
have-
don't just
and
wait
that's- I
months
have
to
it
go
in
in court and
evidence.
you point at each other. What is it he's not doing? What's
He's not
specific?
responding when I'm asking about her toileting,
Okay,
when I'm asking
okay,
about her
but-
potty training.
But what is it he's supposed to be responding to? What does he need to do that he's neglecting? Behaviorally?
Yeah, behaviorally and helping her developmentally. She needs,
How is it, if he walks out of here today and here's step 1, 2, or 3, how I want him to address the potty training?
would be
what
first
would he
to
be told?
communicate. I don't get any
Okay,
communication, I get it.
and let's say we start, okay, communication is different than notice. Neither of you are excused from saying, when I say, why don't you tell the other party this? Oh, he or she doesn't listen, I can't communicate to them. That's fine. Show me that you put someone on notice. Have you put him or his attorney
Yes.
on notice? Here's the steps you need to take.
Yes.
Where are the steps? I get he needs to listen, but what does he need to do when he listens, after he listens?
It involves, it's extensive, and that's the thing, this is very.
Let's paint with broad strokes. What generally should he do that he, is it that he
First, we
doesn't
need
wanna
to
hear it, or he,
communicate. We need
well,
to
hold on,
know
I'm
when
sorry.
it is-
He doesn't wanna hear it, or he hears it, but he dismisses it.
It completely ignores it, and then
Okay.
he completely ignores me when I'm asking about her potty training. Back
Okay,
when we
what
were
is it,
joint custody,
what is it he should do technique-wise or pattern-wise? What is it he
we
should
have
be
to,
doing?
and that's why I have an expert who can testify to this.
But if you're complaining about it and you're the mother, experts are well and good, but you need to tell us, here's the steps he needs to follow. What is he not doing?
Involved, and he's not involved.
Yeah.
It's his girlfriend that's involved.
Okay,
And there's no
okay,
communication.
I think it's my fault, I'm not communicating effectively. It's like, if someone's asking me about the car and I just say, fix it, fix it, fix it, what is it you want me to do? The brakes, the transmission, and then once I get to the brakes, the transmission, what do I do? What is it he's supposed, I get this, generalities about listen, be involved, be conscientious. What specifically does he need to do? And I understand how difficult this is with the diagnosis, but what is it he specifically needs to do that he's not?
Communicate. There's.
Okay, but, and when
To-
this,
and to
when he
actually potty train, he's
communicates
not
and you,
potty training.
but when you
He has
tell,
her
when you,
diaper.
let's say he was a font of open-mindedness tonight, let's just say he miraculously became the open vessel that you want him to be, he's really open and responsive to ideas. What would you tell him to do relative to the potty training?
That we need to remain in open communication.
Oh,
that
okay,
she's
we've
with-
covered that, because I'm not gonna be, I'm going, you see, where this is, I'm trying, you don't realize it, but I'm trying to help you in the event that this is a valid issue. In the event it's a valid issue, I'm bending over backwards to help you. And if I had to make findings now, which is good that you have this opportunity today and tomorrow to fully develop this, I would have to say, I can't make any findings about him neglecting this issue, because you're not telling him what he, again, you just keep saying he needs to be conscientious. You may be right. He needs to listen. He needs to respond. All that may be true. When he does that listening and responding, if he does, what is it he's specifically gonna do relative to the potty training that he's not doing?
And that, I don't know, because he's not communicating what he is or isn't doing. I
Then,
know what I
okay,
have at
if
my
you
house
don't know, then how do you know he's blowing it off and not handling
Because
it?
she has rashes,
Okay.
because of her behavior, because of the fact when she comes to my house, she doesn't wanna be in pull-ups.
Okay,
Because when she's regressed, she was potty trained, and then in his
So-
care, she's coming back.
so
She's had a rash for
should
6
she or
months.
should she not be in pull-ups?
She
let's
should
take
not
that.
be in pull-ups,
She
she's
should
smart
not.
enough.
Have you put that in writing
Yes.
to him?
Yes, and I have extensive
Okay.
text messages.
And
She
you
has a
okay.
rash every time she comes over. For 6 months, she's had
Okay.
a rash.
But you appreciate the fact, you know this 10,000 times more than I, a child who's having trouble at potty train is
But
gonna
she
have
wasn't
rashes.
having potty trouble.
Gonna-
She's smart enough to not have trouble. She doesn't have trouble at my house. And when she does
Okay.
accomplishments and I let him know, I get ignored. The one
Did
night
she ever have an accident at your house?
She does have accidents, and
Okay.
they're far and few in between. And when she does, I let him know. I let him know about our schedule. I
Okay.
let him know when she makes accomplishments. When I let him know that she's in underwear, and I get no response.
If she has, and I could understand it, and that's not to
And
be
if there were both of
tolerated,
us
but we'll
doing
deal with
it.
if that's the case. But if she even has accidents during your 4-hour blocks, why is it unreasonable to think she'll have a lot more accidents during his time?
Because in 3 months, she had absolutely no
Okay.
accidents. She wore underwear at my house completely. We went out and she had no accidents. And she doesn't want to be.
How do I
in pull-ups.
extrapolate that to, that she wouldn't have accidents if she was you 24 hours?
She's probably going to have
And these are
accidents.
not the
It's
questions I
accidents that I'm
feel like,
talking about.
these
It's
are not the questions I
accidents.
feel like asking, these are the questions I'm required to develop these issues. Now,
And that's why you
okay,
said you wanted an
by the way,
expert.
do you have you guys received texts, because maybe she has been on top of this with you guys, have you received either emails or texts, anytime over the last year and a half, how far back we wanna go about this, potty training issue? Would you understand, let me try, and I understand neither of these guys have been sworn, but with your permission, maybe this will help me understand a little. Dad, Mom's not under oath, you're not under oath. I wanna know, what is it you know about this issue? What could be done differently about the potty training at this point?
Well, I believe she will be potty trained at one point. I mean, she's capable of doing it, but she doesn't have the comprehension.
Cringe,
of a lot of
Linus,
things.
cringe.
And potty is one thing. We do work really hard with her on going potty, and we have had her in panties before, and she has accidents all the time. Now, I can't send her to school in panties, or the school will send her home all the time. So most of the time, she is in pull-ups, and she does do a lot better when we're out and about going to the bathroom. But when we're at home, she gets distracted more. But she still has that, she's just not physically and mentally ready
All right,
to do
here's
it.
what I'm hearing from Mom.
I have an expert that says she
What
is
Mom
ready.
says, I'm digging behind what she's saying, that her main frustration isn't necessarily that you're doing all these things wrong, it's just that she can't know what you're doing, and she has suggestions and ideas that the specialists have recommended, but you're just not listening, you're not open to it, you're not communicating. Do the two of you ever speak about these issues?
I can't remember a text message or a phone call from her telling me what she's exactly doing over at her house.
I mean,
to help
about the
the
potty
situation.
training, has there been any conversation for the last, let's say, 2 years about the potty training?
No.
So you guys are making an issue here in court, but no one cared enough for 2 years
Your Honor,
to
I
discuss?
do have proof. I have it right here in the exhibits. I have
She's
proof.
saying
I
that
can show
I'm
you
gonna
right
see
now.
that she bombarded you with texts and emails about this.
We're not gonna dispute that at periods of time, she unlawfully, in violation of the court's order, bombarded my client with all sorts of
There was
texts.
no court order for talking parents, and we can go over that
Okay.
too.
Has this, okay,
Here's a good
digging
very
through all
easy.
that, has this
I'll make it very
issue,
easy for you.
okay, what do you know, about this issue? It's a Down syndrome child, so things are gonna be really difficult. I
have
don't
an
know
expert that can
where she is
testify to
on any sort of spectrum or how advanced or lack
I
thereof
have
she
an
is.
expert that will testify about her readiness, and she's intimately knows her.
Okay,
She can
okay, here's the
testify to her.
problem, and this
She's
is
ready.
one of the reasons why you don't have an attorney. That expert can say this child needs to do all of this, but unless I can make findings that that expert knows for a fact that they've been reaching out to dad or they've spoken to him and he's doing all the wrong things,
She does.
she's been dealing with him, she's
Yeah.
been
No,
interfacing with him.
I've shown her my conversations, my
Okay.
emails, or my text messages to him. I've shown
Okay,
her how
for an
I reached
expert
out
to be
him.
admissible by this court for that conclusion, assuming they were notified of this person and all that procedural stuff in time, for me to, I could make findings that this individual's, which might be helpful to you and your side, that they're an expert in the field, that what they say on behalf of your daughter is in her best interest and should be implemented. But for you to then say, I could make a finding that this is consistently brought to his attention by this expert and he blows it off. You can testify to that, I suppose. The expert can't testify unless she has met with him and has spoken to him and he adamantly refuses.
She can testify to my daughter's readiness and the
Okay.
fact that she knows her. She's known her since she was 3 years old. She saw me potty train her. She saw me
Okay.
implement working with
All
her.
right.
She knows her development and where she should be. In
Do you
fact,
deny she's ready?
Yes.
You deny that she's ready for potty training?
I think she's ready to proceed working on it, but she's not, I deny that she's 100% potty trained.
But you both agree you need to aggressively move in this direction if appropriate, right? She and her expert think it's appropriate. Now, has anyone spoken to you?
No, sir.
So Judge, just to be clear, that expert, there's no expert report. I don't even know what Ms. Hurd's referring to. She's talking about.
Okay, let's say there's no report.
No, there is.
Let's say the person doesn't, okay, whether this person has been validly identified in advance as a witness or not. Let's assume whether they testify or not. What is important, for the purpose she wants this expert for, I'm having a little difficulty. This could be the #1 expert in the world. This expert could have even examined this child 18,000 times. But for the kind of finding Mom wants me to make, I have to be certain that this expert has interfaced with Dad, not just reviewed quibbling emails between them, but that she's had a forensic diagnostic intervention with Dad, and he said, no, I resist all that, I don't wanna hear it,
Never happened.
And it could be true, but it would
It's
have
not,
to
but
be,
it could be.
it would have to be established. Why is it that, when he says we need to work toward it, what specialist is he using?
The child goes, and that's the one thing that I did do in terms of current, Judge, is-
Right.
and that's why
I have every single medical record from the time of the August 2022 hearing through the present, from every single one of the child's physicians, occupational therapists, speech therapists, every single endocrinologist, etc. And I will represent as an officer of the court, but we can spend
Okay.
4 days going through 4,000 pages. You will find not a single note anywhere from anyone indicating any neglect or failure to comply. In
Okay.
fact, all you will see is consistent progress towards the stated goals.
One thing these guys, one thing these guys haven't learned, has anyone, either of them at any point, because right now they're at cross purposes, it didn't occur to either of these people the last 2 years to do the painfully obvious thing. Rather than trying to convince me how cooperative one side is versus uncooperative the other, or who's conscientious or who's not, the court has, I think, in this court, like in most cases, say, don't make me guess at this, or just because put the parties by themselves when attacking the other party don't have much built-in credibility, because they have, like any other party, that have every motivation in the world to tell me just about anything. It would need to be backed up by neutrals. How come it never occurred to either of these guys, just let's make a joint appointment and
I would
see?
love
And then
to do
he'll
that.
say, well, here's what I always thought, and why didn't they just meet with these specialists, but so they can both get the same marching orders?
I would love to do that. I would love to be working with him.
I
That's
appreciate
what I
that.
want.
Respectfully, Judge,
I
I
want
just-
to work with
To
him.
recast, when could they have done that, right? So you have to remember, you issued an order, supervised visits, sole legal, she appealed it.
I don't
So
think I don't think something like that would have been an order or court action being taken if they agreed. One of them wants to be the adult in the room, that's 10,000 times more convincing to me, a 2-page report from someone who meets with them, and here's what I told Dad, here's what I told Mom, I think I'm having cooperation problems with one of them, and here's what I told. That's just 10,000
You know what I
times
mean?
more
Makes sense.
profoundly important to me
I
than
can
someone
tell
just
you
saying,
right now.
oh, he won't listen, she won't listen. How much of this is someone really not listening, and how much of it is control, resistance, obstacle?
Other than being told by Ms. Hurd that, I don't
Right,
know
okay.
where the there is.
Okay.
And that's why I'm referencing the records from the
Okay.
actual physicians that the child sees
Now,
right
all
So
Down
here's all-
syndrome children are different, of course, developmentally, et cetera. But the luck they have luck with children who are not yet potty trained at 4 or 5. Age 7 or 8, it becomes more difficult, and by age 9 or 10, it's rare that they would succeed. Translation, it's either now or never. If they're gonna succeed on the potty training. Who told him, we need to continue to take baby steps on this? Likewise, if I'm concerned about the lack of backing information here, who's told him, though? Let me ask him the same question to him. Who are you using, and how do they think this should be done? When? I mean, what steps?
Well, her occupational therapist has told her that it's like a sixth, seventh sense. It's a feeling that they need to find out. It's not like a touch or sight or sound.
I know.
It's something that they need to figure out on their own, and we can help push that way to help get them there. I've known plenty of people who have kids with Down syndrome that their kids weren't potty trained until they were 13, 12, 11 years
But
old.
those are
And I know one that was
But they
trained-
are-
those
they
are
do become
those are more
potty
the
trained.
outlier, those you need
But,
to get.
and yes,
done
my
with.
daughter, I believe, can and will be potty trained, but it's not an overnight switch like,
It hasn't
This is
been
where-
overnight.
this
It's
is
Right,
been
but
3
when can
years.
it start?
You have this propensity to go off the rails, so can I
When
just,
can
for
it
a moment,
start?
Judge, my
From the
client's
start.
not
I don't wanna
saying-
burn up an hour on this on testimony. I want there to be some
My
uniformity of
client's not,
agreement.
it started, it's not that my client's sitting here in court telling you they're not potty training her, they are. What he's
Maybe we
telling
can
you is
have an
you
agreement
can't-
on this. Do
you
they
can't
agree,
leave the
can they
child-
agree, cause I'm not gonna be able to rule for or against either of these two on the issue until I say, even if she has the best expert in the world, that expert, I need both these parties in the room with some agreed upon specialist, could be that person. I need them to receive their marching orders and see who's gonna comply with it. So who do we,
It can't be that, I mean,
it
that
has
person-
to be that simple.
Okay,
It has to be.
it is that simple, Judge, except for, there's a false dichotomy being created, which is, she wants to potty train and he doesn't.
Right.
But that's not what the
Right.
case is.
I understand what you're
So,
saying.
so it's like, we're going in a circle. He's telling you that he's potty training the child, he's just
The
telling you
purpose,
that
the
they can't leave
purpose
her
of all
panties
this,
all day
though,
when she's at school
the
and she has
purpose for
access.
all this was for them to figure out, which neither of them did, that I wanted someone to say, I will meet in a room with him or her with the specialists, with the experts. I will follow whatever they recommend. We
Absolutely.
both go in.
She has a slew of therapists. We can make an absolutely go see that
I
person.
haven't been allowed to be at any.
Forget
of
what
the-
you're not allowed to
Well,
do.
I will meet- I'll do whatever.
Who would you agree to meet with, and we would follow
She
what they
has-
direct?
She has an occupational therapist who does this, Judge.
Is there any problem if you can meet with that occupational therapist and indicate, here's my concerns?
Okay.
I was told, and here's why, that it should occur sooner and more aggressively, and
No,
here's
an
why.
occupational therapist is who we should be meeting with. I would
Right.
agree with that.
And you can offer your views about if you think it should be, okay, let's get that, because maybe we can avoid a lot of testimony on this. Who do we agree to meet with? She's an occupational therapist, so you agree, can we agree to a joint appointment? Or more than one if need be.
The occupational therapist, the physical therapist, the speech therapist, all through Summerlin Hospital. That's who she sees there. Absolutely, the regular appointments, we have all of those records, right, if you'd like to see what's been going on. But absolutely. And that's what I'm saying, these aren't,
Right,
These aren't
so we would,
complicated.
can we have a stipulation that as long as the parties follow this and no one tries to preempt what the therapist is, do we agree to follow what the experts?
they're,
Because
every single Monday.
we're not gonna keep talking about how great these experts are, and then if they recommend something we don't like, or that we think favors the other side, suddenly we're gonna substitute our parental judgment. We're not gonna do that.
Child
So,
goes to the occupational therapist every Monday, Judge.
it's summer, okay, Mom, if you agree to meet with the occupational therapist, the physical therapist, anyone else at Summerlin, joint appointments, it's probably better joint if you guys wanna meet separately, or one of you wants to be on a video feed, because you don't wanna be in the same room each
I
other.
don't mind, I want what's best for her, I wanna be taking her to her appointments again, I wanna be involved in her life like I was before.
Okay. The idea, though, when you get involved, is if the only way, and I like to leave parents more latitude with things, that choices they can make educationally or medically, developmentally, et cetera. But if you two are in conflict and it's a control thing where one or both of you is trying to usurp the other, then we're just gonna leave it to the specialists. We're gonna leave it to them. If they think this is appropriate for a parental decision, and what mom wants is reasonable and what dad wants is also reasonable, equally reasonable, so I don't really have a view, I'm not taking a stand, then maybe that's an excuse for this type of conflict. But it would be rare that one of these people would say that. They're gonna say, here's what should be done. So you go in there, you write down every single concern you have, potty training, et cetera, and I expect both parties to follow the directives. Can we agree on that? Which means you have to let dad know, send an email to them later this week, when convenient appointment times are for you. And you say you have a flexible schedule.
Maybe.
Here's a set schedule, so try and work with that. He doesn't have that flexibility, I don't think. so.
And that's where the issue is that it's not working with him, it's working with his girlfriend. And so I don't understand why I'm having to
Well, I don't wanna
advocate my
pump up his
rights.
attorney bill by saying Mr. Frieden's office can help with these administrative, ministerial things. But if it comes to that, it has to be, why can't, that could be a particular, let's just assume your girlfriend's better at calendar and things and organizing. That's even, if for some reason it's a sore spot, can we avoid that for now? I mean,
Well, what are we looking for?
I don't mind working with her as long as it's not, there's no hostility in front of the
But
child.
I can't, but that's a subjective thing. If I order you, you have to cooperate with her. You'll be back here saying, in your view, she was hostile. And maybe you're right, maybe you're wrong. I don't know, so I want to avoid it.
So Judge.
I just want to get through I don't want childish
I'm with you,
control
Judge.
stuff between the parties
I'm with you.
to interfere with how they're raising a Down syndrome child. This is not the degree of maturity or cooperation we need from the parties. And maybe it's not, I don't think it's by any means too late, but we may have wasted a lot of the 7 years. So, it's not too late.
I don't know, Judge, I think, I would say that, I think if the actual only things that I've heard that evidence would make sense on is that all of the medical records, which would support the opposite, Judge, would support the fact that this child goes to a myriad of medical professionals and is routinely.
Invite mom to the party each
Next
time.
Well, like I said, they're Mondays, there's a 3:40, a 4:20, and a 5 o'clock, that's speech, occupational therapy, and PT. But I would suggest, simply because, as I understand it, those sessions are the actual therapeutic sessions when they're working with the child.
Are the parents
would be-
permitted to be there?
Yes, they are.
No, they're not, sir.
I wouldn't think so. It would be
I've been
unusual,
going.
but
the whole time, and I would sit in on the sessions. Not recently, since I've lost
That would be a
custody,
little
but when I used
unusual,
to
but I can't
report,
speak to this
You see-
agency.
The representation my
I've been
client,
allowed to sit into them.
the representation my client would make is that since COVID, child
Yeah.
thought they'd take the child back and they do the sessions. What I was going to say is, I would assume that any of these individuals, if we were to contact them and find out if we could do a joint call or a joint, some type of an office hour thing, and or if Ms. Hurd wants to, if Your Honor makes an order, which I think is probably reasonable, to give her legal custody access to talk to these people, and she can have that conversation. I think if she did, what she would see is, and she's got all the records, so we produce them, is that the allegations that she's had about all of this neglect are not reflected in the medical records. It's just the opposite. But if she has some suggestions that she thinks might be something the occupational therapist could do, fine. My client, look, I think while these parties don't agree on much, clearly, Judge, I think certainly my client wants to see Aslan succeed as much as she possibly can. And I think the diligence.
Oh my
there with
God, I was just talking about you.
shown her
Did Fozzie summon you? Did Fozzie say, Bill?
and the myriad of professionals that he continues to take her to, insures her, pays for everything, are indicative of the fact that that is his priority, right? So, and that's all there. That's actually the only stuff that you don't have in evidence, right, is the current medical records. Everything else. on how we got
By
there is
6
already in.
PM alternate Fridays, can you always send her an email, not just a text, but an email dated?
Bill, are you streaming at 8 o'clock today? Because if you are, I can be there. I can watch. I should be done with work by then. So I'm excited.
A number in front of each event or appointment, full sentences, perfect grammar, so there's no misconstrued, saying, okay, this Wednesday, 3 PM, appointment with Dr. Johnson, 1661 South Valley Way, and here's what the issue, just lay it all out. And she'll have full access if she
But
wants to call.
I get notifications while I'm at work. What do I get? Notifications of just videos? Hold on, I have to check out Bill's channel real quick. He streamed yesterday. He did, at 8 o'clock. I got a notification while I was at work. And I don't know what time that was. Damn, you got
Those
me.
people, fine, if she wants to show up for any of it, fine. That way, I think that would be the fair compromise, so he doesn't have to claim, she'll claim he's not keeping her apprised, he'll claim, why do I have to keep chasing
That's
her?
rude.
Reminding her
Michael,
to be a
that's
responsible
rude.
parent. If she really cares about all these things, why doesn't she make inquiry? Make it easy for her and make it easy for him. Here's everything going on the next, or if you want to do it once a month, or whatever. Here's everything that's going on. By all means, we'd be delighted if you participate. Then it's up to her.
Your Honor, absolutely.
Something like
I would-
that. Or
Absolutely.
something.
That's
It
what-
doesn't
that's
have
what-
to be
that's
that,
what-
if they agree on something else.
That's what a legal
fine.
disability and a
Okay.
parent would do, yes,
Okay.
that's,
Do you have another way that that should be
I don't
accomplished?
understand why we just can't do joint custody and go back to the
Let's-
way it
let's
was and
assume-
do this week on, week off, and we
Because-
both be part of her life.
Well, we don't know. However it comes out, you would still want to know that don't assume that just, if you guys are sharing custody, that you're still always going to know what the other side is setting up doing. So I think under any custodial configuration, with this cooperation level, some variation of what I said is a good idea. It doesn't have to be what I said,
No, Judge,
something though.
look, the identity of all the providers she has, okay? Certainly, we can put that together again. The schedules of the therapeutic appointments, I just put on the record, those exist.
Okay, yesterday's. He was on yesterday's.
That the occupational therapist is not doing what they ought to be, or that somehow the representation is, they're recommending that Mario should be doing things that he's not doing, then that can be explored. I can tell you, we have the records, that's not what they say, at all. But that's neither here, that's the reality. So if you want to have that, she wants to have that conversation with the therapist, what have you. I tend to get, and this is kind of almost what I would say to you right at this point, I'm convinced that there's not going to be any there. So given the posture of what Ms. Hurd wants, I'm almost inclined to say, to make your life easy, Judge, if she wants to put the case that she thinks she can put on, to demonstrate that these orders should issue, then I think Your Honor should give her the time.
But
and let her put
regardless
the
of
case
how
on.
it comes out, I want them emergent, whether they like it, don't like it, hate it, I want them emergent with more teeth to be able to enforce on more rights as to how do I find things out? How do I require the other side to put me on notice? Because she's complaining, he doesn't cooperate, he doesn't listen, or more to the point, he doesn't care about her rights. And I think she's synthesizing that somehow into a conclusion that he's totally clueless or wrong as to these therapeutic matters. And just because and that may occasionally be the case, but for her to establish that's the case, it's debatable whether her or any expert's going to establish that they sat down with him, drilled this into him, and he keeps refusing. So I assume you're correct, that's not going to be there. But how do we prevent problems in the future, regardless of how this comes out as far as the schedule? We can at least solve the problem.
Employ a taser often. That will solve your problems.
I don't know anything, no one tells me anything, he or she doesn't care what I think, he doesn't tell me this, she doesn't tell me that. We can put an end to all that childish, nonsensical, control freak BS, and I'm going to. I'm not gonna listen to another hearing after this one about, he doesn't tell me this, he doesn't tell me that, she doesn't do this, she doesn't do that. I'm gonna say, if you guys really care about those issues, rather than just venting on the other side, I'm gonna give you the full rights to put you front and center in front of these specialists.
I will
who, if
check
they
them
agree with
out,
you,
yes.
We're ecstatic if they put it in a report, and then I'll read them the riot act, if that's or vice versa, if that's what's appropriate.
So Judge, I think if I
Yeah.
take you back to 20 minutes ago, you asked me a question about legal custody. I
Right.
told you, I thought that had she shown up for trial, it would have been a joint legal custody case. Okay? I don't think that the physical custody would have looked anything like that, but I think it would have been a joint legal custody case. And that's what you heard me saying, and I said, I
Right.
would understand
Right.
that that would be where I anticipated you would go today.
But
What heard
but
from Ms. Hurd
just
was-
telling them you have joint legal custody without explaining the real life
Well,
manifestations of how we
I
put a
was-
stop to this
I
nonsense
was talking
is
to
not
you.
particularly helpful.
What you heard from Ms. Hurd is she wants sole legal. So what I'm
I
saying
know,
to you,
but-
and I know, and you said no. So what I'm saying to you is, I don't know what else I can offer. I think that when she has legal custody rights, which she never had her parental rights terminated, but she didn't have the ability to, for example, call these providers, right? When she has those,
I think
I
she'll
that
feel a lot
solves-
better
I
about
think that
this. I think she
solves
will.
the entire issue. And I think, again, she's had the records, she's looked through them, you're not going to do the same. What you're gonna see is, there isn't any indicia, Judge, of anything other than a father taking the child to every doctor's appointment, every dental appointment, there.
I think the
If this-
problem is, if some specialist were to tell, if Dad's right, and I don't know, let's assume for the sake of argument he's right and it's a more gradual process. I think she's gonna be a lot more open to that, hearing it from the people who don't have a
Sure.
dog in the fight, except that they wanna do what's best for Ashland. And
Sure.
she doesn't wanna hear that from Dad, nor is she required to unless he is.
Right.
Neither of them is required to abide by the medical or therapeutic or educational directives of the other if they dispute it and the person can't show the proof or documentation as to why it's done. So let's open the gates to everybody. She can speak to, same rights that he has, mirror image. Can speak to these people. Don't get into a situation where you start quarreling with these people, because administrators, bureaucrats, people in the medical field, I'm not saying it has anything to do with these people, but you see, they can cut us off pretty quickly. More so than like dealing with DMV even or something.
We just wanna make sure everybody is acting respectfully, that we're not having issues with appointment cancellations and rescheduling, et cetera. But absolutely, Judge, there's a whole track
It's a little
record.
startling to me that these two, she's saying, should be potty trained now. He said it's more complex, it's gonna take a while. And for 2 years, neither of them has said, well, okay, if we have a basic disagreement on this, so can we meet with person XYZ, and they're the experts, see what they say, and we'll follow it.
I've asked him and he won't
It's like-
answer me.
Like, you and I disagree on how to build a home, we're gonna submit it to architects and carpenters, electricians, plumbers, et cetera, because we don't know.
I would say that Ms. Hurd's
Right.
talking an awful lot about this being this constant debate they were having. I don't see that.
I think
that's
it's
the
more
case.
like they don't communicate on it much of all, and that's a big problem also. Whether she's flooding it with stuff and he blows it off, which is what I'm not hearing, or that it's not happening at all. And in this court, I don't tolerate when, and I said, have you brought this to his or her attention? I'm making this point once more, and someone says, no, I can't talk to him, I can't talk to her. That's not what it's about, that you find the person obnoxious to interact with, so therefore you don't have to abide by the other side's constitutional rights. Then view it as a notice requirement. Put them on notice in a polite, civil, direct way. Here's what I'm seeking to establish, etc. So we have an agreement. If we walk out of here today, is there anything, and he's required to provide that, just as you will if you start making appointments and you're gonna put him on notice every other week of this email, are you gonna have any problem with meeting with any of these individuals?
No.
Okay, good. I'm hoping we save some time with that. Okay. So we have a stipulation, as you said earlier, that
I'm hoping we save some time, he said.
as you said, so legal custody is not appropriate, at least not anymore, and you've agreed on that. We have some framework where how we're gonna deal with developmental issues. Translation, we're gonna leave it to the experts who have a gazillion years of education and make their living at this, not making it a venting control
Cringe.
issue against each other, because that's what I'm sensing. They don't like things because it's the other side doing it or telling them things, not because
But
it's.
Judge, can I just, for just a little clarity, that's not what's gone on here.
But the same, but likewise, it covers it, I've covered, if it's total BS and he only hears about this, no one said a word to him about it for a year, and now he's hearing about it in court, that possibility is covered also. If she's sincere about this and really means it, but never notified him, he now understands what, you know.
All I mean to say is there were very specific reasons why Ms. Hurd went from having full access and talking to these people and being at these appointments to not.
That's why I'm
And those
saying we
reasons
have
were-
to
hang on.
calibrate our behavior.
Those reasons were her conduct. that
I
resulted
covered
in
it, I was
coercion.
aware of it, I knew, I don't wanna beat a dead horse.
That's all.
She knows to calibrate her behavior as he does, and if they don't, and someone cuts someone off, that's another thing that's covered. I don't want someone coming into court and saying, I don't have records because of something the other side did. So if someone's cut off for whatever, I want you to ask whoever's in charge, at Dr. So-and-so's directives, because of obstreperous behavior on such and such date by this party.
It wasn't
Yeah.
that, Judge, it was
Right.
because of arrests and drug use.
Right. We did it. We made it to 2024. Yes. Now we're on the downhill. We're in the same court with the same players. One will just go right into each other after this. There is no OJ today. Good job, Gemma. 5 months. You're almost got a gold star. Almost. Yes, that's it. What do you mean that's it? It's been 2 hours and 17 minutes. I need to get this off my head. Thank you so much for coming out, guys. I really, really, really appreciate it. I love this case. I'm glad we're doing it. And I shall see you all. I work a double today, Anthony. So I'll see you all tomorrow. Bye, guys. Or I'll see you in American Courts later tonight if he streams. Gold star. Gold star. Bye, guys.